Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-5087. Nicolas Talbott et al. Versus United States of America et al. Appellants. Mr. Campbell for the appellants, Mr. Minter for the appellees.
Good morning, Mr. Campbell. We'll hear from you.
Good morning, Your Honor. May it please the court, Abhishek Kamble for the defendants, and I will be reserving 3 minutes of time for rebuttal. Your Honors, this court should follow the lead of the U.S. Supreme Court in the D.C. Circuit Stay Panel and allow the military to institute its policy of presumptively disqualifying those with gender dysphoria. With medical conditions in particular, we begin with the premise that most Americans are disqualified from the service. 71% of 17 to 24-year-olds in America would not meet the medical requirements to join. And so the military can certainly presumptively disqualify someone with a mental health condition, which the record shows, 1, requires 9 times the amount of mental health encounters as the average service members. 2, makes them non-deployable for a period of time if they're undergoing cross-hormone treatment. And 3, have triple the cost per capita as regular service members. This policy is subject to nothing more than rational basis, informed by military deference, and it easily passes that standard, and we believe the injunction should be vacated.
The last statement you made about triple the cost per capita, where is that in the record?
Yes, Your Honor, it is in JA 112. It was part of the Mattis report. So, Your Honor, one case I wanted to spend a little bit of time on is United States v. Skermeti. One of the reasons that it's especially important is that it provides a clear roadmap for how this case should be decided. So the question in that case boiled down to what the policy classified, or in that case, the statute classified on its face.
So could I ask you a question? Your brief says that the question before us as to the 4 factors for a preliminary injunction is whether the district court abused its discretion. That's at page 20 of your brief.
Yes, Your Honor.
All right. So an abuse of discretion standard anticipates alternatives are available to the district court, absent Congress having spoken directly or the Supreme Court haven't spoken directly. So you say in this case we should follow the Supreme Court's entry of the stay. Now, what was the reasoning behind that? Do we know?
So, Your Honor, there was an unreasoned stay order, but the D.C. Circuit panel also provided some reasoning in its
What
stay.
did the Supreme Court say?
The Supreme Court just said that the injunction is stayed.
Right. Okay. So we don't know exactly for what reason.
That's correct, Your Honor.
Okay. So absent that, and your brief saying there's an abuse of discretion standard for us to consider, isn't the implication then that there were alternatives available to the district court?
So, Your Honor, legal questions are still reviewed de novo, and we do believe that the district court's error was on the law, which does automatically mean that it abused its discretion when entering the injunction.
And which law are you referring to?
So, Your Honor, based on the precedent that we have available on this issue, so one of the cases that came out after the district court entered its injunction was United States v. Skermeti, which
I understand that. All I'm trying to get you to acknowledge or not, so I'm clear. When I read your brief and you said we were to look at the 4 factors to determine whether the district court had abused its discretion, you didn't talk about erred as a matter of law. So that said to me that the government was acknowledging that, at least at this point, prior to the Supreme Court ruling in this case and telling us why, or Congress speaking directly, that the district court had some alternative options available.
So, Your Honor, we do believe that there's multiple reasons that the district court, or so one example is entering a universal injunction.
I understand that. I just want to be clear that you're sticking with what you said in your opening brief.
Yes, we do believe that the district court abused its discretion in entering an injunction because it doesn't meet the 4 factors for a preliminary injunction.
All right. So do you also agree in this case, all of the plaintiffs are currently serving?
So, Your Honor, nobody has been discharged under the policy at this particular point in time.
And secondly, that they are both transgender and I may mispronounce the term, gender dysphoria.
Yes, Your Honor, we believe that all of them would be presumptively disqualified under this policy.
So these are people who have been serving in the military. And at least our president has spoken very highly of military operations. And under this policy, as I understand it, all of those people would be discharged unless their supervisor says they're absolutely necessary and indispensable and all of those things.
So, Your Honor, it's given that this policy classifies on the basis of a medical condition.
Yes.
It's not unusual, even if someone has served honorably, to be discharged on the basis of a medical condition, absent a waiver.
In this case, is it correct that the disability evaluation system would not be available for these people who have served in the military?
So, yes, Your Honor, and I want to talk to you a little bit about that.
And is the answer yes?
Yes, it's not available.
That system would not be available.
That's correct, Your Honor.
So is there any other medical condition for a military person who's in the military now, who has a medical condition, does not have this case-by-case determination under this system that the military has created?
So, yes, Your Honor, let me explain. So under Section 1642 of the FY 2008 NDAA, it requires that the Department of Defense use the schedule for ratings disabilities with the VA and have it be consistent with them. So that just
Hold on, I need to get that down.
Yes, Your Honor.
So you're saying the NDEA.
NDAA of fiscal year 2008, and that's Section 1642.
And that is what, the appropriation?
Yes, Your Honor.
All right, that's the Appropriation Act. And it has this language in 1642.
Yeah, so basically the disability evaluation system is for people to get a VA rating, and it requires the
And
military.
VA rating means what?
Means a disability rating where you get a certain percentage of military retirement. It's basically medical retirement. And one of the.
So if I went through this system, it's possible I might be discharged on disability?
Yes, Your Honor, and then you would collect a VA retirement. And the VA publishes the conditions in 38 CFR Part 4 Appendix C that qualify for disability, and gender dysphoria is just not listed. And that was the case even under the last administration. So that's not anything new.
Is there any other condition that's not, where this system is not available? Medical condition?
Yes, Your Honor, there's whatever is listed in that Appendix C is typically what is allowed for VA
Do you
disability.
have any idea what's in that appendix?
I have glanced through it. It's hundreds of medical conditions, but gender dysphoria, even under the last administration, was not one of them.
Give me an example.
So I don't know off the top of my head what
All right,
specific.
All right, so can you just provide us a record site so I can go look at that list of 100?
I don't have anything in this current record, but it's 38 CFR Part 4 Appendix C that has the VA listed conditions that qualify for
And so
disability.
you're giving me thousands of pages to look at.
So, Your Honor, that's where that's available, but we don't believe that that's ultimately a determination of whether this passes rational basis review because.
I understand that, but it is relevant to the answer to my question.
So, Your Honor, we do believe that that's a separate inquiry from whether this passes rational basis review and whether this was a pretext for animus, which is what the plaintiffs were
So you
ultimately
think
arguing.
my question is irrelevant?
I don't believe that, Your Honor. What I do believe is that the disability system is a separate inquiry than whether this policy passes muster.
It may not be dispositive, but I need to understand who is eligible for it. And what you're telling me is that there are hundreds of people who, if they have these conditions listed in the Federal Register, are not eligible for this case-by-case evaluation.
So, Your Honor, that's by statute. The military is required to align its.
Is that your answer to my question? I just need to be clear.
Yes, Your Honor. So I'm not aware of any of the specific conditions that are not listed there, but gender dysphoria is not one of them, and it's not the only one.
But you have no idea what's listed.
I don't know the full universe of
I
what's
know you
in
don't
there
know
yet.
the full. I just want one example.
I don't have that off the top of my head, Your Honor.
Okay, thank you. Sorry.
So,
I'm just trying to clarify, was this in your brief that the disability evaluation system excluded gender dysphoria even under Biden?
it was not in our brief, Your Honor, and it's not in the record. It was just something I had that is in statutory and CFR citations.
Okay.
Well, it came up at one of the earlier hearings. So the government was certainly on notice about this issue.
Yes, Your Honor. And but that is my understanding of the reasoning why that it's there. But it ultimately, the important question is, what does the policy classify on its face? And in this case, you do have.
I have a question about the compelling government interest exemption, for lack of a better word. So let's suppose you have a currently serving service member who has gender dysphoria diagnosis, they've transitioned, they have changed their gender classification in the DEERS system, I believe it's called. So let's suppose, for the sake of this hypothetical, it was a person who their birth sex was male, they transitioned to female under the Carter policy, Carter-Austin policy, and the Mattis policy allowed them to remain, and they changed their marker. Under the Hegseth policy, that individual is presumptively disqualified, but if they meet this compelling government interest, they can stay. But my reading of this is that this transgender female service member would be allowed to stay only if she served under the male standards, her birth sex standards. Am I correct?
So, Your Honor,
The policy?
there would be a separate reason that they wouldn't meet the waiver criteria. The waiver criteria requires that you never transitioned or attempted to transition your gender. So that is the main difference between this and the Mattis policies, that there is not that grandfathering provision.
So as to these plaintiffs, then you acknowledge it's a ban.
So, Your Honor, yes, these plaintiffs will not be able to meet the criteria for a waiver.
Okay, so I'm trying to, so I just want to make sure that I am understanding you correctly. At JA 53 to 54, where the policy appears, I apparently have misread this because I thought that under, I guess it's at 55, J55, under retention, it said that paragraph C, 4.3C, says that service members disqualified because they have a current diagnosis, gender dysphoria, or they have a history of treatment, could be considered for waiver on a case-by-case basis, provided there's a compelling government interest in retaining the service member that directly supports warfighting capabilities, and the service member concerned meets the following criteria. So you're saying that the under 2, the service member demonstrates that he or she has never attempted to transition to any sex other than their sex, means that the person in my hypothetical would not follow under this retention policy. So who would, of the people who were retained under the Mattis kind of grandfathering, or the reliance exception, as it was called in Judge Williams's concurring opinion in Doe 2 v. Shanahan, who's the universe of people that this retention policy could apply to?
Yes, Your Honor. So it involves someone who's trans-identifying, but not everyone who's trans-identifying necessarily receives a diagnosis for gender dysphoria. So those people would be allowed to serve. If they do have a diagnosis for gender dysphoria and they have 36 months of stability, they have never attempted to transition sex and are willing to serve in their biological sex, that person would also be retained. And Your Honor, I see I'm out of time, but I'm happy to stay as long as there's questions.
Oh, we got more
Yes.
questions. So Mattis allowed people to remain in service and even continue to transition and change their gender marker based on this reliance exemption.
Yes, Your Honor.
Including recognition that retention standards are generally less stringent than accession standards, and that the commitment of the service members and investment that the military had put into people and training them, et cetera, all of that justified allowing people to stay in kind of in reliance on the kind of Obama era policies. I found the only explanation I found for Secretary Hegseth revoking that judgment of Mattis was at, I think it's JA 65, in a single paragraph. Is there any place else in the record where I can find a justification for revoking that policy?
Yes, Your Honor. So one aspect of that, of the Mattis policy, they did have a grandfather clause, but it wasn't because there was no risk associated for the military with allowing those troops to serve. It was just a matter of where they drew the line as to where you can't serve. But one example is JA 93, that's also in the Mattis report. Those with gender dysphoria had an average of 28.1 mental health encounters during the period that they tested, while the average service member had 2.7. So it is going to be of a common sense that says those with the mental health condition will seek mental health treatment more often than the average person. So some of those types of things and costs would never change. But it goes back to what this policy classifies on the basis on its face, which is what United States v. Skermetti talks about. And that came out after Doe 2 v. Shanahan and can provide some light on that.
I understand that, but I guess all I'm saying is that even under strict rational basis review, the Supreme Court has struck down lots of statutes, state constitutional amendments, policies under rational basis review, based on the fact that some sort of difference in treatment or classification is arbitrary. And there's reams of case law about, the government can kind of change its mind, and a new administration has a prerogative to change policies of the last administration. But generally speaking, you have to A, acknowledge that you're changing, and B, give a rational explanation for the change. And it may be that the court, might think that that's not the best reason or whatever, but that's not for us to weigh. But we have to at least see an acknowledgement and an explanation. And I guess what I'm asking you is, what is the explanation that was given where Mattis knew all of the costs, knew all of the risks, but said, based on reliance interest, the investment, service, we're willing to essentially take that risk and let these people stay who began treatment, even began transitioning under the Obama era policy. And Hegseth comes and says, if you've attempted to transition at all, you don't get a waiver at all. You're out.
So, Your Honor, that goes towards, so when we're talking about that, it's talking about where we draw the line. So both the Mattis policy and this policy obviously have a presumptive disqualification for gender dysphoria, but where they draw the line as to when someone can get a waiver and stay and when someone can't is the difference. And that is an area where there's military deference that should play a role in that calculation. So when we talk about military deference, we're not talking about necessarily which studies the military considered and why. It's a separation of powers principle that says that courts are ill-equipped to make that judgment.
I didn't really hear an answer to my question. So what was Secretary Hegseth's explanation for drawing the line differently than where Mattis had it, where he essentially relied on mostly all of the same evidence that Mattis had?
So, Your Honor, they obviously relied on the Mattis report. The Mattis report does talk about those with gender dysphoria seeking mental health treatment at 9 times the rate of an average member. It talks about triple the cost. It talks about how people undergoing cross-hormone treatment also end up being undeployable for a year. So all of that is something that the military considered, along with the 2025 literature review, which talks about the strength of evidence for treatment for gender dysphoria being low to moderate, those with gender dysphoria having 13 times the suicide ideation rate and a higher likelihood of other disorders. So that 2025 medical review combined with the Mattis report does provide a rationale that survives rational basis informed by military deference.
Some of that data, A, is not like even in the military context, but B, I think more to the point, you have people who have been in for years and are serving fine, getting Bronze Stars and other commendations, and you adopt a policy revoking a reliance exception by predecessor without even looking at data for how it's worked and how service members who were allowed to stay under that reliance exception have performed and what problems they have presented or what costs they have presented, what risks they have presented.
So
there's no attempt that I can see in this record to ascertain the answers to any of those questions.
So, Your Honor, the stat that I presented, it's on JA 93, the number of mental health encounters. That was looking at
A93?
JA 93.
JA 93. Right.
Yeah, that was in the Mattis report, and it measured outcomes within the military. And even the RAND report, which was the policy or the study that was designed to, or the basis for Secretary Carter to allow those with gender dysphoria to serve, even that states that those undergoing undergoing cross-hormones treatment would not be deployable for a period of a year, and that's in JA 104. And then in JA 106, one of the things in the Mattis report it talks about is that it cited that the RAND study itself said all of its information must be cited with caution because much of the current research on transgender prevalence and medical treatment rates relied on self-reported non-representative samples. So what we have here is an area of medicine which we can all agree that there's a certain level of uncertainty over. The military does not necessarily is allowed to make predictive judgments and doesn't have to wait until a situation arises in order to pass rational basis to perform a disqualification based on a medical condition. And there are numerous medical conditions such as high blood pressure or others where a member can serve honorably but can still get disqualified from service as a result of that. So that's why it goes back to what does the policy classify on its face and how that fits within rational basis viewed through the lens of military deference, where the military is in the best position to make the call on predictive judgments. So that's also brings me to my next point. There was no disagreement.
Before you totally move to the next point, you said one thing that I just wanted to make sure I heard correctly. I think you said that under the Mattis policy, a person with gender dysphoria whose transition is in progress and who wants to serve with a gender different than the gender they were assigned at birth, would be allowed to continue serving under the reliance exception. I wasn't sure if I heard that right or if the Mattis policy distinguished between a reliance exception for people whose transitions were complete, but not a reliance exception for people whose transitions were in progress.
Yes, Your Honor. I believe that there was a certain cutoff date as to when you had to finish the procedure by under the Mattis policy. I don't have that date off the top of my head since it went through, obviously, a number of lawsuits before it was allowed to be implemented. But but at the time, because the policy did not take effect right away, there were some people who, after the report came out, completed their transition. But I do believe that there was a cutoff date to when you had to have your sex marker changed in years.
At least some under the Mattis policy, at least some people whose transitions were in progress and who wanted to serve under a preferred gender that was not their birth sex would not have been covered by reliance exception.
Yeah, I believe that it depends on when they met the cutoff date. If they met the cutoff date, then they were covered. If they didn't meet it and didn't complete the process, then they were not covered. So that's also why there is the importance of military deference and line drawing. So every administration, including the Obama and the Biden administration, did draw the line somewhere at gender dysphoria. It wasn't just unrestricted service if you had that medical condition. There was a period of stability. There was options for how you could get a waiver. But the Trump policy here the Hegseth policy here just draws the line at a different place. And that's why we do have the idea of military deference, because it begins with the presumption that courts are ill-equipped to decide where the military should draw its line, and especially when it comes to personnel where that's at its apogee. And when the district court did was pierce the veil of the evidence for what the military considered and attempted to poke holes in it. But the district court can't substitute its own judgment for that of the military. So when you look at what you do have here, you have a policy that easily passes rational basis review that is informed by military deference. And you can't say that it's for any other purpose other than a bare desire to harm an unpopular group. So that is why this court should follow the lead of the Supreme Court and the state panel here and allow this policy to take effect. And
how does the compelling government interest exception, I don't see anything in the record that indicates how a service member would apply to be able to for the waiver.
Yes, Your Honor. So the policy is still being implemented, but the compelling interest just boils down to effectively what are the needs of the military. So that is what if there is a need for that position.
I understand what the policy says. I'm trying to find out how is it administered.
So, Your Honor, at this point, no waivers have been decided. So we don't have any examples of what that would look like in practice. JA 1289 to 90 talks about what the implementation looks like. And the implementation is primarily based on the records review and the member's annual physical health assessment. And so far, no one has actually been discharged under the policy. So we don't have any decisions on waivers yet.
Does that language at JA 1289 to 90 say how a service member applies for the waiver?
So typically what would happen is the member before their discharge gets notified that they have, that they're subject to discharge, and they would get an opportunity to present the case before an administrative discharge board. And that's where they would put in evidence of why they would qualify for the waiver and be able to apply for that as well.
Is that in the record, or are you just telling me what you believe to be the case?
So, Your Honor, the JA 1289 to 90 talks about the process that it's going to have an initiation of a discharge board. It doesn't say exactly what a compelling government interest would be. And Your Honors, if there are no further questions, yeah, that is all.
Could I ask just a question? You say no one has been discharged. There's no commitment not to discharge
That's correct.
tomorrow.
So, Your Honor, the practical way that it would work is until that member's time for a yearly physical health assessment is in place, that's when they would identify who is in the universe of someone that has gender dysphoria. And even then, they would have to go through a discharge process that would take some time.
Counsel, we started out by your acknowledging that all the plaintiffs, we know about them, so they could be discharged tomorrow.
Everyone would still go through the process that the military has laid out.
Process?
The process where they would be identified, get notified of a discharge, and then go through a board if they elect it, or be able to provide information. But that has not happened at this point.
I understand the process, but the argument is the end result is foregone. What's the word I'm looking for? You know, it's predetermined.
So yes,
So it's a meaningless process. It's just moving paper around. There's no chance that one of the plaintiffs could continue to serve.
So, Your Honor, they would not meet the criteria for disqualification, which is based on the evidence that they have presented in the record.
So
I want to be clear that while the government says no one's been discharged, the way I read the policy, there's absolutely nothing to prevent the government from discharging all the plaintiffs tomorrow.
So, Your Honor, even if they were discharged tomorrow, that it goes towards the issue of irreparable harm. There is an avenue if the Supreme Court later changes its mind and enjoins the policy for reinstatement with back pay that happened with the COVID-19 vaccine. So even if that were to happen.
All speculation, have no idea what the Supreme Court may or may not do, because in other cases, it's been very deferential to the military. And it really hasn't cared about any individual.
So, Your Honor, what I can say is that the process is moving forward, and because of the Supreme Court stay, the military is allowed to go through with the process of
Right. So that's my point. Everybody could be fired today or tomorrow. There's no process. There's no procedural protection. And you say, well, the Supreme Court could come along and provide it. And I agree, the Supreme Court could, but for these plaintiffs today, there is no protection. And all I'm getting at is under an abuse of discretion standard, isn't that the type of consideration that a district court may properly take into account in weighing whether or not to issue an injunction?
So, Your Honor, that part would go towards irreparable harm, but that type of harm is normally reparable. So the district court would be incorrect to say that that's
How's
irreparable
it
harm.
reparable?
Excuse
counsel?
me. Yeah, I'm sorry.
How is it reparable?
Because someone
All
can
I'm
be,
saying is the district court has found it's not reparable. All right?
so Your Honor, the Supreme Court also weighed the equities in deciding whether to grant a stay. And one of the things that they have to weigh is harm to both sides.
No
And
question about that, all right? But all I'm saying is the Supreme Court may come forth and provide the protection. But I'm just saying the plaintiffs, as of this moment, do not have that protection. It may come, but right now, the Supreme Court has acted without giving reasons.
so, Your Honor, the Supreme Court has allowed the policy to go into effect, but loss of employment is typically not considered irreparable harm under this circuit's
How
precedent.
about damage to career, damage to personality, damage to reputation, et cetera? I mean, when you lose your job and you're told that you're all these terrible things and you couldn't possibly serve honorably
So,
in trying to defend your country against all enemies, foreign and domestic.
So, Your Honor, the Supreme Court has never held that reputational damage is irreparable, but to the extent that it is a factor in this case, everyone who gets discharged receives an honorable discharge. So when they do apply for a job, they would see that they have served honorably. So we don't believe that the reputational
so
harm would be
you're-
there.
I'm just curious about this because in a lot of employment law, there is this question about whether a future employer can inquire as to the reasons for your being let go at your previous job. And there are some state laws that don't allow that type of inquiry. All right. And some federal laws even come close. But I don't see anything here that protects against that.
So, Your Honor, there's no evidence in the record of what their future employment will be and how this would harm them, especially
I know.
when they
And
get an
there's
honorable discharge.
Nothing in the record about how they wouldn't be harmed. What you're saying is just all speculation.
No, Your Honor, we do believe that what they have presented evidence of, which they have the burden to, is loss of employment, which is generally reparable. And then you
I
also,
understand that, but what about the fact that they lost the employment because they were dishonorable? They were not honest. They were not trustworthy. They were not capable of defending and carrying out military orders.
so
A
Your
whole nother ball of wax that has nothing to do with what amount of pay you take home every day.
So, Your Honor, ultimately, they do get discharged with an honorable, and typically in most job applications, they did ask if you served in the military and what was your service
Okay,
characterization.
typically. So you want us to look at this case, even though there's no protection out there, in terms of saying, as I understand it, that the district court abused its discretion in looking at the potential weighing of these factors. All right, at least this court so far hadn't said that the first factor is dispositive of everything. All right, so you get into the balance of equities, et cetera. And your argument to us, as I understand it, is the military certainly has the right to decide it wants to take a long-range perspective on who is qualified to serve and continue serving in the military. And that's the explanation, period.
So, Your Honor, the DC Circuit has a heightened requirement for what a plaintiff who has the burden of demonstrating that they meet irreparable harm should meet. And based on the record that they presented, it's ultimately a loss of employment where they get an honorable discharge. So we don't believe that it meets the threshold for irreparable harm, especially when weighing against the government's interest in carrying out its military policy.
My understanding was that at the oral argument before our court at the stay posture, it was represented, and this is reflected in Judge Pillar's opinion, that there is no other medical condition that automatically triggers administrative separation from the military rather than individualized medical evaluation, other than gender dysphoria. Was that representation made?
So, Your Honor, I wasn't there, but when you're talking about the involuntary separation process, which is different than the Disability Evaluation Board, I'm not aware of which particular medical conditions are subject to that. It is getting into the weeds of exactly how the military classifies things. But what I can say with the disability evaluation system is that it's based on a disability process to get a VA disability. So my understanding is based on the statutory requirement and then the VA because gender dysphoria is not listed, that's not a new requirement is what I was getting at.
Okay, so administrative separation, which was referred to in the prior panel, what is that?
Yes, Your Honor. It's a process that is playing out and where you get a discharge board that states the basis for your discharge, and then you get an opportunity to present. Normally, you have to have 6 years or more in service in order to be allowed to have a discharge board. But for this particular condition, they're allowing anyone, regardless of service time, to have it. And then
it is in your sentence, just so I'm clear, what is it?
It's a panel of 3 officers that determine whether there's a basis for discharge and
Just
whether
honorable discharge.
they automatically get an honorable if they are separated under the policy, but you
No,
still.
I understood that. But the question, I thought in response to Judge Wilkins' question, was you were going beyond that.
I'm sorry. So, because
When you
normally.
go for a 3-member board.
Yes. And the reason that I was saying that is because normally for someone to have an administrative discharge board, they're required to have 6 years or more in service. But this one, they're allowing people who have less than 6 years of service to have a hearing in front of an administrative discharge board. So that's the difference.
What would you get at the end of that? That's what I'm trying to understand.
So for instance, they would have to determine whether you meet the criteria for presumptive disqualification, and they could also provide a recommendation for the waiver, but the waiver is ultimately going to be decided at a higher level, and the discharge has to be finalized at a higher level too. But you do get an opportunity to present your case in the front of a board, which is what this process entails. It's not only designed for misconduct, so that's why it's a process it's basically the due process the member gets before being discharged. They're not just getting summarily discharged from the military is the big picture point I was making.
So I'm just trying to understand, your position is that an administrative separation before the discharge board, in the government's view, even if it is, even if gender dysphoria is the only medical condition that triggers that process, your argument is that that's not any sort of a disadvantage or prejudice or stigmatizing people with gender dysphoria. Is that your position?
Yes, Your Honor, because it's a form of due process, and at the end of it, they get an honorable discharge.
Okay, I just want to understand that. So I want to understand your position with respect to animus.
Yes, Your Honor.
The district court found that there was animus. I didn't see anywhere in your briefing where you attacked that finding or asked us to set aside that finding for under the clear error guidelines, which I believe would be our standard of review. Did I miss that?
So, Your Honor, we do believe that it's a legal determination that should be reviewed de novo. But the point that the state panel and the Supreme Court made, and one of the cases I wanted to draw the court's attention to is a recent Supreme Court stay opinion that's on point for this case, Trump v. Orr. That was the case involving biological sex to be displayed on passports. And it was also based on a executive order that used similar language that's here. And there was an animus finding in the district court. And when the Supreme Court had its stay opinion on the issue, Here's what it said, and I want to make sure I'm reading it verbatim. But it says, quote, respondents have failed to establish that the government's choice to display biological sex lacks any other purpose than a bare desire to harm a politically unpopular group. So there was no clear error review or anything else that the Supreme Court utilized when making that determination. So that's why we do believe that it's a legal determination to be reviewed de novo as the Supreme Court treated it in Trump v. Orr.
Well, I thought that, maybe I'm wrong, but what the court was saying was the record shows that there were other reasons, not that it's a question of law.
It said that on this record,
In other words,
respondents have
United
failed to
States
establish.
versus Hawaii, doesn't the Chief Justice talk about, if you can find some reason somewhere, somehow, that's enough.
So yes, Your Honor, the standard is that it has to be, in order for a policy to be struck down on animus, it has to be inexplicable by anything other than animus, or another way to put it is that it lacks any other purpose than a bare desire to harm a politically unpopular group. And that the way the state panel described it is basically the absence of a rational basis. And that's the way that we believe that it survives rational basis, which then negates the possibility of animus being controlling.
So do you think that it works that same way, whether it's intermediate scrutiny or strict scrutiny, that evidence of animus isn't really relevant? You just look at the objectives expressed by the state, and then you see whether the fit matches.
Yes, Your Honor.
Or a closer fit for intermediate scrutiny, and you require a really tight fit for strict scrutiny, but as long as there are some legitimate objectives, we don't really care about animus. You think that that's the way that the analysis works?
Yes, Your Honor, because animus by its very nature is irrational. So if it can't pass rational basis, then it can't pass intermediate scrutiny or strict scrutiny in that scenario. So we do believe that here it's subject to rational basis. And if there is a legitimate, and everyone agrees in this case that the reasons the military stated are legitimate reasons. So unit cohesion, readiness, and costs are all legitimate interests. It's just a matter of whether the means of presumptively disqualifying those with gender dysphoria are rationally related to that. And we do believe that there's plenty of evidence in the record, such as the statistics I was citing about the number of mental health encounters, the time away from a deployed environment for cross-hormone treatment, and then also the triple the cost per capita, and the fact that this is ultimately an evolving area of science. Things that we thought we knew, it turns out not to be the case. Justice Thomas had a concurrence in Skermeti that talked about WPATH. WPATH used to be the gold standard for all of this type of medicine, and then it turns out that there was a lot more going on than just being a neutral body. So when you have this much uncertainty, the military is.
Let me just drill down on animus, though. I'm trying to make sure I understand your position. So let's suppose you had a president and a defense secretary that makes statements for, this is a hypothetical, but clearly display animus. I hate people of a certain race, hate people of a certain religion, hate women. It's in the executive order. It's in the defense secretary makes lots of statements, tweets, speeches, etc. And then it's followed by a policy that might get heightened scrutiny because there's race or gender classification to it. Are you saying that when a court reviews that policy, the animus that it would find by the policymakers kind of outside the four corners of the policy document is completely irrelevant? We just look to see whether there's legitimate kind of reasons that are stated in the four corners of the document, and then how tight the classifications fit those objectives? We don't care at all about animus if that were the case?
So, Your Honor, it depends on what the policy itself says and does. So one of the things that United States v. Skermetti talks about is, the identity between, like say it's a medical condition, for instance. This court did hold in Doe 2 v. Shanahan that not every trans-identifying person necessarily suffers from gender dysphoria. So you at least allow a subset of those people to serve. So it depends on what the policy does, who it incorporates, and then that determines the tier of scrutiny. But at the same time, race and religion are a little bit different because Students for Fair Admission in other cases say that you can't use something else as a proxy for race. That type of precedent is missing from intermediate scrutiny, which if it's not subject to rational basis, that's what it would be subject to. So there's a little bit different when you're talking about race or religion because there is that proxy issue. But the general rule from Trump v. Hawaii that was later applied in Trump v. Orr is that if it can be explained by anything other than a bare desire to harm a politically unpopular group, then animus does not control.
I have a follow-up to the question about automatically triggering separation. And I think Judge Williams read, I think Judge Wilkins, Judge Williams' opinion is going to be part of my questions later. But I think Judge Wilkins read the sentence that said, the government cannot identify any other medical condition that automatically triggers administrative separation instead of an individualized medical evaluation regarding continued fitness to serve. Or if it wasn't that sentence, it was, I think, getting
Yes, Your Honor.
that. And that's a sentence from Judge Pillard's dissent. So, and then you kind of segued into a description of what an administrative separation hearing would look like. But just, I think, is that statement correct that for any other medical condition, you are not automatically separated? You instead get an individualized medical evaluation.
So, Your Honor, it's a very complicated with the administrative processes that the military utilizes for any condition. What I can say is, though,
Of course it is. And you're going to help us understand it by simplifying it to the core issues we have to decide.
well,
And that's why, with all due respect, Judge Walker's question is so pertinent.
yes, Your Honor. So there are a lot of medical conditions under the VA system for discharge. So I'm not aware of, which particular ones would be excluded, but other than gender dysphoria has historically been excluded. The difference was under the Carter and Austin policies, they were allowed to serve. So they weren't discharged.
Let me try asking it this way. There's got to be some medical condition out there that would, in 100 cases out of 100 cases, require separation.
Yes, there are non-waivable conditions.
Okay, so what's one of them?
Schizophrenia.
Okay. So in that situation, that person would get an individualized medical evaluation, correct?
I don't know the answer to that specific one, but
So it is possible that that person would not get an individualized medical evaluation.
if it's not on the list from the VA, then it wouldn't go through the disability evaluation system. But I don't know whether they would necessarily be discharged through the administrative separation process or if there's some other medical process that's out there.
I thought you answered these questions when I asked them. Are you changing your answer in responding to Judge Walker's question?
No, Your Honor, I'm just answering the question of what qualifies for the
You
disability.
told me if I looked at the Federal Register, I'd see all of these conditions that were disqualifying, and you couldn't think of any. All right?
So
now you're telling Judge Walker schizophrenia is one, and if you're diagnosed as a schizophrenic, you're out without an individualized review. Is that what your response
So-
to him is?
So, Your Honor, the disability evaluation system is one specific process. So it came up in Judge Pillard's dissent. So I was addressing that in particular. There are, the military has, in each service has a different, various ways of discharge. So I don't know off the top of my head if there's any other procedure outside of the disability evaluation system or the administrative process that member would be discharged. But I do know that gender dysphoria was not a condition for the disability evaluation system, and that the administrative discharge process is the method
This
utilized.
disability evaluation system that is connected to the VA,
Yes.
does that have to do only with what benefits you receive after separation, or does it have to do with whether you are separated?
It's both. It determines if you're separated for the medical condition, and the VA also utilizes that to determine your VA disability rating.
Okay, and let's take the example you gave of a condition that would be disqualifying in 100 times out of 100 times. And let's compare that to gender dysphoria under the Hegseth policy. Would a person in either of those situations have any better chance of staying in the military than the other?
The person with gender dysphoria would have a better chance because there is a waiver process.
Okay, and then putting aside the waiver process, they would have an equal chance because they would both have a 0 chance.
Yes, Your Honor, because both are disqualifying conditions, and there's obviously hundreds of different conditions that can disqualify you.
Yeah, and these are not hostile questions or friendly questions. I was trying to understand the person who would go through the individualized medical assessment. That person is getting a process that is different than an administrative separation hearing, but not a process. Your argument is it's not a process that's better than an administrative separation hearing because in both situations, the conclusion is foregone.
Yes, for the most part.
Putting aside the waiver issue.
Yes, and the other thing is there was one additional benefit that those suffering from this medical condition got that others didn't, which was a severance package if they voluntarily separated.
That's people with gender dysphoria.
Yes, Your Honor. So that's a benefit that they get that those with other medical conditions don't.
And is that where the 6-year thing comes in, or is that totally separate?
That's totally separate.
Okay.
That goes towards whether you can get a discharge board.
Okay.
But that's also another benefit.
I don't understand why, when an equal protection challenge is raised, and the very issue that Judge Walker and I have been exploring was identified in a published opinion in this case, the government doesn't come with clear answers, because what you have just told Judge Walker, there are all sorts of qualifications. It's not clear. I mean, generally, but there could be exceptions. And now we hear about this, exit package. I don't understand this argument. I understand the argument. It's the military's decision to make, stay out of it, courts. I understand that. The question I had, and that's where I started, was you told us that our standard of review of the district court's ruling on the 4 factors for a preliminary injunction was abuse of discretion.
Yes, Your Honor.
That means under our law, the Supreme Court laws, there are alternatives that are permissible unless the Supreme Court has addressed the issue directly or Congress has addressed it directly. And you acknowledge that while the Supreme Court has acted, it hasn't told us why. And it could have acted the way it did for a number of reasons, including the CASA issue. It has nothing to do with what we've been talking about basically this morning. I just don't understand how a court can apply abuse of discretion standard that the government says is what we are obligated to do and not take into account who the plaintiffs are, how the government defended its case, and the questions Judge Wilkins has been exploring, unless you think the courts have no role.
So
And that may well be your position, and I understand that. But I'm just saying, I don't think any of the judges on this court, including the two in the majority, who just found they were likely to succeed on the preliminary injunction. That's as far, that adverb is a qualifier. Okay. So now we're into the preliminary injunction itself, and the government says abuse of discretion. So to me, the government is saying there is a role for the court. All right? And it's not telling the military how to run the military or who to let in or let out. But it is saying that for these plaintiffs, maybe there are some issues that need to be addressed. And that's what the district court did. And I understand your criticism of the district court. But the questions we've been raising, it seems to me, go to, if you tell us abuse of discretion, then don't we have to follow your instruction and apply that standard to the best of our ability?
yes, Your Honor, we do believe that there was an abuse of discretion in this case because, one, the policy was just subject to rational basis review framed by military deference, so the plaintiffs were unlikely to succeed on the merits. And the Supreme Court's, in its ruling, did at least address the equities because they couldn't have granted a stay without addressing balance of the harm. So we do believe that that.
Well, with all due respect, they could have addressed it on the CASA issue. Okay. So what Judge Wilkins, I thought, was trying to pursue with you is we had an administration that had a different view, at least with this reliance exception. And as I said, and it's not in the record, I know, but the president has been on television, radio, and at Davos praising the military and all that was done in the Caribbean and the Air Force. I mean, so apparently he likes what's going on with the people who are there now. So aren't they perhaps to be viewed differently under an abuse of discretion standard? And it seems to me those are the kinds of questions that the district court was raising. And I realize you don't like the answers, but they are pertinent questions, it seems to me, that we just ignore.
So, Your Honor, this ultimately boils down to a facial challenge to the military policy, and to hold that.
Well, abuse of discretion doesn't tell me that, okay? It says that there are alternatives that are potentially available, and you may not be persuaded by them. And I understand that, and we may not be persuaded by them, or the Supreme Court may not be persuaded by them. But abuse of discretion doesn't tell me this is a slam dunk on a facial challenge.
So, Your Honor, it's still, in addition to the stay, it still has to be read in light of other Supreme Court precedents. So, United States v. Scrimetti, for instance, came out after this case was decided. There was no, so on this one, it classifies on the basis of a medical condition, so it has to be rational basis. So one error the court committed was utilizing intermediate scrutiny, or then there's Trump v. Orr that came out afterwards, which also talks about how.
It's the hypothetical. We currently have a military that is doing extraordinary work, according to the president. He wants to look long-term. That's what the Secretary of Defense tells us. And so the policy going forward is looking long-term. So we're not going to let any of the type of people that the plaintiffs are in. But the question that I think we're all dealing with is, what do you do with the people who are there?
Yes, Your Honor.
Have been serving.
Yes, Your Honor.
You haven't given us a clear answer. You're talking about all these boards and they can buy out and all that sort of stuff.
So, Your Honor, what matters is whether there's a rational basis for discharging those that are already in there.
That's right. Where there is nothing to say to us that they are not doing one hell of a good job. That's all I'm getting at.
So, Your Honor.
And you say just ignore that.
So, Your Honor, there's hundreds of medical conditions where someone can do a good job in the military and they're still subject to discharge, and it doesn't necessarily mean that the military can't do it. So the question is, when it classifies on the basis of a medical condition, including for existing service members, whether there's a rational basis to do so, and we do believe that the record contains that.
So,
Go ahead.
so the appellees on their brief at page 4, footnote 2, say that the Air Force issued guidance saying that transgender service members could only appear at their separation proceedings if they appear in their birth sex.
Yes, Your Honor.
So if they have transitioned, and I'm assuming they have their Deers marker or classification changed, the appellees represent that they cannot appear at their separation proceeding. Do you dispute that that is the case?
No, Your Honor, we don't dispute that. And that goes towards uniform and grooming standards, which the military is allowed to draw the line on. And the case that I would cite on that is Goldman v. Weinberger, where there was an as-applied challenge to a service member who wanted to wear a yarmulke.
I'm familiar with that case, but the denial of them appearing at a proceeding in which the issue is going to be decided as to whether and under what conditions they're going to be separated from the military, that decision, which is part of this policy, is not based on a medical classification of gender dysphoria.
So, Your Honor, that goes towards what someone has to wear when they're in military service. And the military does get a lot of deference with where to draw the line on uniform and grooming standards. And the military, as a policy, has said that it has to be based on biological sex. So they would be doing nothing more than what every military member currently has to do. And that still applies during a separation board.
But my point is that you say that the only thing that this policy classifies based on is medical diagnosis.
Yes, Your Honor.
And under Scrimeti, then, okay, that's not heightened scrutiny because that's the only thing that this policy really kind of treats people differently based on. But it's not the only thing that this policy treats people differently based on.
So, Your Honor, they're in front of the discharge board in the first place because of a medical condition. And the uniform guidance is so, like, under the Austin and Carter policies, unless you have a diagnosis of gender dysphoria and take all the steps necessary to transition, you're required to serve, right, to wear the uniform in your biological sex and adhere to those grooming standards. So it's just a matter of whether they draw the line or where they draw the line on that policy. And that would be a little bit of a different challenge than what we have here, because challenging the uniform policies would still be a little different, and that would still be subject to substantial military deference, because even in a scenario where strict scrutiny would normally apply, the Supreme Court applied military deference and deferred to the judgment of the military when it comes to uniforms.
So I'm trying to make sure I understand this. If a person has already transitioned and they've changed their gender classification marker in the system. They're not subject to the waiver.
Correct.
Are they subject to this administrative separation? Yes or no?
Yes.
But they wouldn't be able to appear at their hearing because they can't appear in their birth gender, right?
If they choose not to, then the hearing would continue in absentia.
What do you mean if they choose not to?
If they don't appear in the uniform and grooming standards of the biological sex, the board would continue, but just without their presence.
Let's,
And, well, if it's a follow-up to that, go ahead.
let's imagine someone was born male, someone has transitioned to female, and they want to appear at the administrative separation hearing. You're saying that that person, even though that person has transitioned already, that person could come to the hearing dressed and groomed as male and would still be entitled to appear in person at the hearing.
Yes. Yes.
So I have a question about CASA. So trying to make sure I understand the government's position as to what the district court should have done. Let's suppose I know you believe the district court should not have imposed an injunction at all because no likelihood of success on the merits, no irreparable harm, et cetera, et cetera. For the purpose of this hypo, if this district court or any district court, in a challenge like this, imposes an injunction, what are you saying should have been the scope of the injunction? How should it have been worded?
So, Your Honor, if speaking solely to scope, it should have been limited to the named plaintiffs in this case.
So it would say that the order says at J1207, I'm looking at it, it says that all these various officials and departments are preliminary enjoined from implementing Executive Order 14183, as well as this guidance, any other memoranda, blah, 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 blah. Period. You're saying that a proper injunction under CASA would say those same things with respect to plaintiffs A, B, and C, or the named plaintiffs. That's what it should say.
That's correct, Your Honor.
So it could still be a facial challenge, but even a successful facial challenge would only get an order granting relief to the named plaintiffs in the facial challenge.
Yes, absent a class certification, that would be the limits.
I have a yes or no question on the standard of review. I'm going to read from Wisha, and I'm going to ask you if you agree this is correct. We review the district court's decision to grant the plaintiff's request for a preliminary injunction for abuse of discretion, its legal conclusions de novo, and its findings of fact for clear error. Is that correct?
Yes.
And what does your brief at page 20 say?
Yes, it says to obtain the extraordinary remedy of a preliminary injunction, a plaintiff must establish that he is likely to succeed on the merits, that he's likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equities tip in his favor, and that an injunction is in the public interest. The court reviews an order regarding preliminary injunctive relief for abuse of discretion. Any underlying questions of law, however, are reviewed de novo.
Mm-hmm. So do you see where you cite Winter?
Yes, Your Honor.
And what does your sentence say after you cite Winter?
It says this court reviews an order regarding preliminary injunctive relief for abuse of discretion.
Right.
And Your Honor, getting the law incorrect is abuse of discretion.
No question about it.
So
You agree that the Supreme Court has yet to decide this case, although you say there are all kinds of signals as to how it's going to decide it.
So, Your Honor, we do believe that the Supreme Court's stay should be to provide guidance to the court, but at the same time, it's inconclusive as to the merits.
Any other questions? All right. If you have any kind of concluding remarks or something that was important for you to present that we waylaid you from presenting, give you a couple minutes to do that and wrap up.
Yes, Your Honor. So it's clear that there's a raging debate across the country about the issue that we're arguing here today. And it's also a rapidly evolving one. So as I mentioned earlier, the WPATH was presumed to be the gold standard for this field. And Justice Thomas's concurrence in Scarmetti notes that their studies have proven to be unreliable. So when you include the level of uncertainty we have with this particular issue, the military was and should be careful with gender dysphoria, and it gets significant deference for where it draws the line. So the proper question for this court is whether the military did what the guidance said it did, which was classify on the basis of a medical condition, and then whether it passes rational basis review that's informed by military deference. And if that were the case, the law does not prohibit what the military's decision was, and we ask that the injunction get vacated. Thank you, Your Honors.
Thank you. We'll give you some time on rebuttal. Morning, Mr. Minter.
Thank you, Your Honors. May it please the court, yet Shannon Minter appearing for the appellees. Your Honors, the Hegseth policy seeks to do something totally unprecedented. It proposes a mass discharge of thousands of concededly qualified troops, including service members who've deployed around the world in dangerous assignments like Iraq and Afghanistan. They've received multiple awards for valor and performance. The government actually concedes that these plaintiffs, every single one of them, are qualified. They've met every standard with deployments before, during, and after transition. In the district court here, very carefully analyzed the entire record, had a 3-day hearing, and reached the conclusion that this policy is driven by unmistakable animus. The court repeatedly acknowledged the deference owed to the military, and for that reason gave them every opportunity to provide evidence of considered judgment supporting this policy or to rebut the very extensive evidence put forward by the plaintiffs. And the government repeatedly declined to do so. They rested on their position, which we've heard here today, that they can simply assert a facially legitimate reason and don't have to substantiate that in any way. And so they're now asking this court, having made that decision, to reweigh the evidence. They disagree with the court's findings of fact because they disagree with them. And now we're even hearing new testimony from counsel today about facts. But, that's not clear error. And I know this court's very well aware
Can I
that's
ask you about some of the terms? When people are transgender, they have an internalized, felt sense of their gender that does not align with their sex assigned at birth. Is that correct?
on this record, Your Honor, there was questions that in Dovey Shanahan, there was confusion about what's the definition of a transgender person. I can tell you that the plaintiffs in the district court here took that confusion very seriously. And the record on this case is crystal clear, unrebutted evidence that a transgender person is someone who lives or would do so if able in a sex different than their birth sex.
Okay, so you disagree with that definition of transgender?
That definition, it can be understood in a very misleading way. We've got testimony from Dr. Brown, who was also the expert in Doe versus Shanahan, to clarify that his testimony talking about a person who identifies as a sex different than their sex at birth was misconstrued to some extent there was questions raised about it.
What would the proper term be for someone who has an internalized felt sense of their gender that does not align with their sex assigned at birth, and who has no distress or impairment, and who has not transitioned, and who does not desire to transition? What would the term be for that person?
Well, I think what the record in this case shows is there is no such person. That Dr. Brown clarifies in his supplemental declaration that somebody.
Okay, I think I have the answer. You think that person doesn't exist. In the opinion by Judge Williams in Doe 2 v. Shanahan, he cites a RAND report. That RAND report that I think had been relied on, if not, had been relied on by one of the secretaries of defenses. It says 55% of transgender people live in their preferred gender. Another 27% wish to transition in the future. That leaves 18% of transgender people who have not transitioned and don't wish to transition. So you disagree with that RAND report?
I would refer the court to Dr. Brown's supplemental declaration where he addresses these
Just asking
issues.
what your position is.
Well,
maybe we can discuss later whether why you think what you think. But I'm just asking, is it your position that RAND report is wrong when it says 18% of transgender people have not transitioned and don't wish to transition?
The record in this case.
That's, I mean, I think,
Your Honor,
I think all the judges, I want to know what you're right. I'm not asking for your personal subjective opinion, but I am asking for your client's litigating position in this case.
Well, they agree with what's put forward by the expert that
So your client's litigating
submitted.
position in this case is that the RAND report is incorrect when it says that 18% of transgender people have not transitioned and don't wish to transition.
I think that cannot be meaningfully understood without the context provided by this expert report where Dr. Brown explains that, of course, there's people who for a period of time, for a variety of reasons, family rejection, employment discrimination, other types of external discrimination, and just the process of coming to terms with being a transgender person, it's not an instantaneous process, it's a developmental process. So yes, but what he makes really clear is that by so yes, there will be at any given time, if you took a snapshot of the entire population of transgender people, there would be people who are transgender and who have not yet come to terms with being transgender, have not yet reached the point where they're able to muster the courage and the effort it takes to go through transition. But it's very clear that
I mean, you've been
that
pretty
is
critical of the
definitional.
Defense Department here for impugning the courage and honesty and integrity of your clients. And now you're saying that people aren't courageous if they are trans but don't wish to transition?
No, Your Honor,
That
I'm in
sounds like
no
what you're
way
saying.
saying that. I'm saying that Dr. Brown makes very clear that part of what it means to be transgender, just like non-transgender people, there's an internal drive to live congruently with your identification. That's just as true for a transgender man or a transgender woman as for a non-transgender man or a non-transgender woman. It is very much part and parcel of what it means to be a transgender individual.
So it sounds like you're adopting Dr. Brown's position, and you're describing Dr. Brown's position as there will at any given time be a number of transgender people who, for whatever reason, perhaps family dynamics, any other reasons that you listed, there will be at a given time some number of transgender people who have not transitioned and at that time don't wish to transition.
I think with the context provided by Dr. Brown, yes.
Okay. So I think that then leads to my next question, which is, what is gender dysphoria? One understanding is that gender dysphoria is distress or impairment because someone identifies with a gender other than their birth sex. Is that definition correct?
The definition that's in the record in this case, again from Dr. Brown, is that gender dysphoria is the distress a transgender person will feel if they're unable to or prevented from being able to live congruently with their gender identity, if they're unable to live in a sex different than their birth sex. Eventually that will cause distress.
Okay, so that is a little bit different than the definition that I suggested. And so I think you're saying someone who feels distress or has impairment because they identify with a gender other than their birth sex does not have gender dysphoria unless the distress or impairment is caused by their by the fact that they have not transitioned.
That incongruence between your identity as male or female and being seen by others and having to live in your birth sex is the source of the distress. That's my understanding of the clinical literature and what Dr. Brown explains.
Okay. Then is it true here what the plaintiffs in 2019 said? They said a requirement to serve in one's biological sex is a transgender ban. That's your position here, right?
Yes, sir.
Okay. At the time, they wanted a return to the Carter policy, Secretary Carter, that required transgender people to serve in their biological sex until their transition was complete. Do you think that Carter policy was constitutional?
Yes.
Okay, so you would not object to a policy that requires transgender people to continue serving in their biological sex until their transition is complete?
I think that was a reasonable policy to enable a path forward for transgender people to transition in the military.
Okay. Is what you propose consistent with this? Any person who remains biologically male, any person born male who remains biologically male in every respect can demand to be treated in all respects as female, including medical fitness, physical fitness, uniform and grooming, deployability and retention standards, as well as for assignment to birthing, bathroom, and shower facilities.
I'm not sure what you mean by can demand that.
Well, is constitutionally entitled.
No, that is not, we have not argued that.
Okay, so what of that is not constitutionally required?
Your Honor, we're not here saying the Constitution mandates some particular policy. We're here challenging an animus-driven policy that excludes all transgender people. We don't have a position on that.
Okay, so you don't have a position on whether it would be constitutional for the military to require someone whose sex birth is male, but who says, treat me as female. You don't have a position on whether it be constitutional to require that person satisfy the physical fitness requirements for a male.
No, our position is that the policy that's at issue in this case is unconstitutional because it's animus driven and targeted.
So it would be constitutional for the military to require someone born a male who has transitioned to female. It would be constitutional for the military to require that person to wear the uniform of a male and be groomed like a male.
No, I'm definitely not conceding that. I'm just telling you that we're not here to say the Constitution mandates a specific military policy. We're challenging the one that has been adopted.
But it would help to know how you understand the Constitution, how you understand the equal protection aspect of the Fifth Amendment. And I guess you're saying you don't know whether the equal protection aspect of the Fifth Amendment requires the military to allow a transgender female to wear the uniform of a female?
All I know, Your Honor, is that this policy that is been adopted hastily and with animus towards transgender people and is designed to intentionally exclude them, even though they're qualified to serve, does not meet even the barest requirements of equal protection.
You cannot answer also whether it would be constitutional for the military to require a transgender female to be groomed as a male.
We don't have a position on exactly what the Constitution requires about these specifics. Again, just that the
Okay.
policy can't be
I just want
animus
to.
driven and
You
designed
don't have
to
a position
exclude.
on whether the Constitution requires the military to assign a transgender female to female shower facilities
No, Your Honor.
or bathrooms,
No, Your Honor.
or to be required to meet the deployability and retention standards of females.
No, just that whatever policy existed has to be rational and not fueled by animus.
I do have more questions, but I know I've monopolized the first
Okay.
quite a bit, so pause.
Let's suppose, for the sake of argument, that the court agrees with the district court that animus was present and played some sort of motivating factor with this policy. Given Trump v. Hawaii, what work does the finding of animus do, or put it colloquially, what does that get you?
Thank you, Your Honor. Yes, I think that Trump v. Hawaii and the court's other animus cases tell us that once a district court finds, as a matter of fact, that a policy is fueled by animus, then the burden then is on the government to show that there is some actual legitimate purpose at work and that the policy would have been passed, that absent animus, the same policy would have been enacted. I think that's,
So you believe that it operates to shift the burden to the government?
I think, Arlington Heights, made very clear that once animus is shown, the deference that's ordinarily afforded is suspended. And then there is the requirement that and I think this comes through in Judge Pillard's dissent very clearly as well, that the government then does have to show that there was an actual legitimate purpose that is served by the policy. And that better explains the policy.
Okay, I want to drill down on this. So, a plaintiff challenging in a government action as unconstitutional has the burden of proving that that action is unconstitutional.
Yes.
What language in Arlington Heights or Trump v. Casa or any of the other animus cases you have cited suggest that once animus is shown, then the burden, so to speak, of persuasion, proof, however you want to put it, shifts to the government?
Yeah. I think the language in Arlington Heights, I just cited, said that once animus is shown, the deference that is ordinarily afforded under rational basis is no longer justified. And then the government does need to show that there is some other legitimate reason. I mean, the Supreme Court in Trump versus Hawaii, I think, is a great model of that, where the court takes that requirement very seriously and very methodically looks at all of the evidence that showed in that case. It's all missing here, but that showed in that case that there was a legitimate, substantial reason for the policy that was not fueled by animus, and they went through a number of factors.
I agree with you
Yeah.
that that's what the court did there at the part that's in the subsection D, so to speak, where they apply the standard of review. But I guess what I'm trying to get at is that seems to go to kind of fit and maybe the level of scrutiny is a little bit enhanced than kind of what it normally might be with rational basis with no animus. I'm just not sure that I see from that part of the opinion that there's some sort of a burden shifting where the presumption is then because there's animus that the law is unconstitutional, and then the government then kind of has to, given that presumption or the shifting burden, be on the hook to persuade the court that no, it really did have legitimate objectives that the law was trying to meet. That's why I'm trying to help me understand.
Understand. Yeah, I did find the site for Arlington Heights. It's at the site is, it's 429 US at 265-66, where there's proof that a discriminatory purpose has been a motivating factor in the decision. Judicial deference is no longer justified. And I think the necessary implication there is that there then, once animus is shown as a motivating factor, the government does need to show that it would have enacted that same policy absent the discriminatory purpose. And I think that's, again, Judge Pillard's understanding of how this case law works as well. And I think you see that reflected in the line of cases from Cleburne, Moreno, Romer, Windsor, where once animus is shown, that what the court then requires the government to not just to articulate a hypothetical or possible legitimate basis, which would ordinarily be enough under rational basis review. You don't ordinarily have to show it was the actual purpose, but the court in every single one of those cases requires more than that. They require some indicia of truth and independence is, I think a quote from one of the cases, an indicia of truth and independence that there really is in actuality, that the actual purpose was whatever justification the government is asserting. And then the courts look there to a number of factors to assess, do we believe that it's not a heavy burden? I mean, you just have to show that it's truthful and that there's a truthful actual purpose and that it's independent of the animus. But here the government did not think it needed to do that, and it declined. The district court asked again and again, "Give me something, tell me something." And the government here, they wouldn't even explain why.
Let me put it this way: the Obama era policies under Secretary Carter, Secretary Austin. Or wait, no, Secretary Austin was under Biden.
Yeah.
So the Obama era policies, those policies treated gender dysphoria differently, where it was disqualifying for accession, for joining the military unless the person was stable for 18 months, right?
Yes, sir.
And even then, if they were admitted to the military, they would have to serve under the standards of their birth sex, not their preferred gender, right? So.
No, sir. Sorry, not under Secretary Carter's policy. No. The whole accession policy, the whole point was if you'd already transitioned.
If you haven't transitioned, I'm talking about somebody who has a diagnosis of gender dysphoria and who has not transitioned.
And they're seeking to enlist.
They're seeking to enlist.
They cannot do so until they've transitioned and been stable for 18 months.
transitioned and been stabled, or have stable in their
No.
diagnosis.
No, sir, that's that was not the policy under our Secretary Carter. It was designed to reflect the reality that gender dysphoria is very treatable, that many people undergo the treatment transition, they're perfectly stable. They need very minimal, medical treatment going forward. There's no reason to keep them out. But they just wanted to know, basically, have you completed your treatment and are you stable in your post-transition status? And if so, fine, and you meet the other qualifications, you're welcome to join.
So if somebody has a diagnosis of gender dysphoria and they said, I don't wish to transition, I'm willing to serve under my birth gender. And, I'm under doctor's care and through kind of counseling, other sorts of treatment, not hormonal treatment or surgery or anything of that nature that's typically associated with transition. Through this other treatment, I'm stable. You're saying that under the Ash-Carter policy, that person would not be allowed to join the military?
Yes, sir. I am saying that. Yes, if they have a diagnosis of gender dysphoria, that would have ruled them out. If they had not completed treatment and been stable in that post-transition status. Yeah.
Treatment as in transition treatment, not treatment as in I don't want to transition. I just want to, feel good about kind of who I am, etc.
Yes, sir. Because, diagnosis of gender dysphoria includes the distress component. I mean, it's caused by not being able to live congruently with who you are. So, yes, anyway, that is my understanding anyways, that policy, they would not be able to join.
So thank you for clearing that up for me. But I guess what I'm getting at is, in general then, if the Ash-Carter policy treats gender dysphoria differently than other medical conditions, so to speak, and it's kind of presumptively disqualifying, except if you've transitioned, been stable, etc. And if there's no contention that that was based on animus, then how do you reach the conclusion that the Mattis policy or the Hegseth policy, as far as accession to the military goes, is based on animus because it targets gender dysphoria?
Yes. Well, so the whole goal of the Secretary Carter policy was to approach gender dysphoria the same for accession purposes and retention, but we're talking about accession. For accession purposes, the same way they would approach any other treatable medical condition and apply the same kind of analysis and criteria and so forth. So there are plenty of other treatable medical conditions that don't keep you out of enlisting in the military as long as you can show that you've undergone the treatment and that you're, stable. So it's just applying that same, it's a very equal treatment kind of framework. They just apply that same framework. Like, let's stop singling out this condition because it's associated with transgender people. Let's stop treating it differently. And let's just look at this the same way we would look at any other medical condition. So that's how they came up with those criteria. And that is, a very legitimate good faith effort to just be even-handed and come up with a reasonable policy. That's very different than what's going on here, which is an animus-driven desire to exclude transgender people entirely and treating gender dysphoria because of its association with transgender people completely differently than the military treats any other medical condition, whether it's for purposes of accession or in the retention context.
So I want to make sure I understand the kind of different categories that your plaintiffs, your clients fall into. There are some, it's my understanding, who are seeking to join the military and are thus challenging the accession policies, right?
Yes, sir.
How many fall into that?
Two.
category? Two. And then the remainder are already in the military serving.
Yes, sir.
And how many of those joined the military prior to 2016?
Your Honor, I apologize. I cannot give you the exact number.
Are there some?
I believe there are. Yes, there are. Yes.
So, and it's my understanding, but I want to be clear on this, that all of them have a diagnosis at some point in their history of gender dysphoria.
Yes, sir.
Are there any of them who you are contending no longer would no longer be diagnosed with gender dysphoria? I mean, in other words, you know, I could get the flu, I could go through a course of treatment, and then I would go back and the doctor would say, you no longer have the flu. So you are no longer diagnosed with the flu. Does that happen with gender dysphoria? Or any of your clients, these plaintiffs, saying, that's me, I no longer, my current diagnosis would not properly list me as having gender dysphoria?
Yes, sir. That is a feature of how this condition, the treatment is very effective. So yes, it is. Once you receive the treatment, the dysphoria dissipates.
So is it in the record that some of these plaintiffs have a current diagnosis that says you no longer have gender dysphoria?
Your Honor, I apologize. I don't know the answer to that. I don't know if any of them have a reflection in their medical records that their dysphoria, gender dysphoria has been
But
resolved.
your litigation position, posture theory apparently doesn't turn on that.
No, sir.
And senior moment. I've forgotten what my next question was, so proceed.
While you're thinking, I will just.
I have some questions along the lines of
Okay.
Judge Wilkins' questions. Before 2016, did military policy bar people with gender dysphoria from service?
That term was not used in the policy. It used different terminology.
But what we now call gender dysphoria, whatever term was used back then, before 2016, military policy barred people with that from the service.
I believe the terms used were transsexualism and transvestism were barred.
And
I'm sorry, what was your answer?
The terms in the back then were transsexualism and transvestism. That was the terminology used. Yeah.
And that answer may be the answer to my next question as well. Before 2016, did military policy bar transgender people from service?
Yes.
I'd like you to consider this situation. A person was identified male at birth. Later, that person joins the military. Later than that, the person identifies as female, adopts a female name and female pronouns. Before 2016, did the military allow that person to continue serving in the military?
You know, I don't believe I know the answer to that question.
Can I just make sure I understand the question? the person, if the person still served under the standard of their birth sex, but maybe they adopted a female name and used she, her pronouns, you're saying you don't know if that person would have been disqualified. But if the person had tried to change their classification in the DEER system, DEERS, right? Isn't that it?
Yes, sir.
If they had sought to change their classification to female, that wouldn't have been allowed prior to 2016, would it?
Correct. That's my understanding. And thank you. That's very clarifying. I mean, one of the reasons Secretary Carter took this issue up is because there were individuals that, such as you were just describing, who were serving in the military, identify as transgender, and had taken steps to transition and were, living as a sex different than their birth sex, and some of them were very high performers and doing a great job. And there was some ambiguity about what to do with them or how the military should address that. And that is one of the reasons that Secretary Carter wanted to examine this policy and come up with a way to a more modern, way to address it.
But to answer Judge Walker's question, that person may or may not have been disqualified for, just because they were trying to transition and using a different name and different pronouns, but they wouldn't have been able to change their classification. And perhaps if they insisted on that and insisted on wearing the women's uniform rather than the men's uniform, it seems likely that they would have been removed from the military, right?
Based on the policy on the books, yes, sir. Yes, sir. Yeah. I think in reality it existed in a kind of de facto gray zone, but yes, the actual policy on the books was to exclude people. And part of what the military recognized, that was not a rational policy, and commanders were coming forward and saying, look, I have transgender people serving. These are valuable members of my unit. Can you be requesting that the military come up with a new policy?
All right. I apologize for interrupting. I wanted to get clarity on that point.
Definitely no apology necessary. That was really helpful, and thank you for phrasing it the way I was trying to phrase it and failing to phrase it. Under the Hegseth policy, could someone serve who feels like they are a gender different than their birth sex, but has not transitioned and has not been diagnosed with gender dysphoria and is not displaying symptoms to other people of gender dysphoria and is willing to serve under the service standards of their birth sex?
Well, at the hearing, when district court judge asked counsel for the government, is there some person who's not excluded by this policy? The only example they could come up with is what I believe was referred to as a village of one, that we could imagine someone like living on a desert island who has privately unexpressed thoughts in their head, and that person might not be excluded under the policy, but any expression, including stating something or expressing it in any visible way or sharing it with somebody else, is going to trigger the provisions about someone having symptoms of gender dysphoria. And actually the person is required under the current policy to report that themselves. So they're required to self-report. So I guess that would be an important caveat here, that such a person, based on the current policy, is required in their annual health assessment to self-report any symptoms. And that is a symptom of gender dysphoria. So they would be required to report that, and then that would trigger a kind of investigation, review, evaluation process.
And is your understanding that that is different than the pre-2016 policy?
Oh, yes. There's no similar requirements. In fact, I don't think anything like that has ever been required for any medical condition at all. It's a pretty extraordinary new policy that anybody who has symptoms consistent with gender dysphoria is required to self-report that. In fact, the military is actually changing the form for every single person serving in the military, which the district court estimated to be about 1.3 million people. And now every single person, when they fill out their annual health assessment form, has to literally attest whether they have gender dysphoria or symptoms of gender dysphoria, all in an effort to find these 2,000 people who, by the government's own concession, are qualified and meeting standards. And again, this is an important piece of evidence about why this is not a medical policy, because that actually turns any sort of legitimate medical framework on its head, and it's a complete departure from the retention policy for literally every single other medical condition, where the focus is on fitness, like, can you do the job? And once somebody is in the military, and this comes through very loud and clear in the Mattis report, the focus is on trying to keep people in. You've invested enormous resources in them.
I do think I understand that answer, and I'm grateful for it. And I would like the government on rebuttal to tell me if they agree with what you just said about the self-reporting. I think you're saying that the government views even an internalized, unexpressed sense that your gender does not align with your birth sex as a symptom of gender dysphoria that must be reported to the military.
Well, that is a symptom of gender dysphoria and the DSM, and then there's a policy that says
Does the military understand that to be a symptom of gender dysphoria?
I believe so. Yes, sir. Yeah. I mean, I think they say they follow the DSM. So, yeah.
So I want to ask them that, and that's helpful to know. I want to ask you, please, under the Carter policy at the end of the Obama administration, and I think Judge Wilkins was asking about this. Imagine a person born male, later identifies as female, and then later wants to join the military.
Or military.
On the last day of the Obama administration, does the military let that person join? Does the military let that person join?
It sounds similar to the question Judge Wilkins was asking.
I think it is.
If they have a diagnosis of gender dysphoria, then no.
If they have a diagnosis,
No, they can't join.
That is my understanding of that policy.
I mean, that's not what the policy says. The policy says that if you have a history of gender dysphoria, it's disqualifying unless it's certified by a doctor that the applicant has been stable without clinically significant distress or impairment in social, occupational, or other important areas of functioning for 18 months. I don't see anything in there that says stable because they have transitioned.
Well, I think the necessary implication of the portion you just read about stable without clinical distress means they no longer have gender dysphoria because they've undergone treatment. So That's my understanding of how this policy works.
It seems like we're getting to a point where maybe you want to die on this hill, but your position, at least litigating position, seems to be there is no one who has a diagnosis of gender dysphoria who doesn't seek to transition. Or where transitioning in the sense of either hormone treatment or surgery.
Or social transition. It does not necessarily involve any particular medical treatments.
Okay, social transition, not necessarily medical treatment. I thought that, so I may have, forgive me, I may have misunderstood one of your earlier responses. But let's suppose it's a non-medical, not hormones, not surgery, but socially they seek to transition, and the way they choose to do that is to ask people to refer to them with, if they're born as male, refer to them with she, her pronouns, use maybe a feminine variation of their legal birth name. And based on that, counseling, other interventions, they are stable and they say, I'm willing to stay in the military and adhere to the standards of my birth sex. Are you saying that that person doesn't exist? It doesn't appear to be any of your plaintiffs, of your clients, but I'm trying to understand your litigating position. Are you saying that such a person does not exist or could never exist? That's what I'm trying to understand.
Oh, gosh, Your Honor. So you're saying someone who has socially transitioned, but is willing to, is living as a sex different than their birth sex, but would be.
At least,
Yeah.
maybe in all other facets of their life, wherever they can, they live in their preferred gender, but for military purposes, they will adhere to the military's standards for their birth sex with respect to grooming, uniform, bathrooms, where they sleep, all of that. But their treatment for their gender dysphoria is such that they don't want to do or choose to do any of the medical transitions. Are you saying that that person doesn't exist? Or I'm just trying to understand.
You're right, that person may exist. That person may exist. You're right that it does not reflect any of the plaintiffs here. I don't think there's anything in the record one way or another about whether that person exists.
Because if that person existed, that person could potentially, under the Hegseth plan, stay in the military under a waiver, right?
One obstacle there would be the very clear statement in the policy that expressing what they refer to as a false gender identity divergent from your birth sex is incompatible with military service. So I think that might be an obstacle there.
And I guess the language, it says you can't have tried to transition.
Yes, sir. I think.
So even if it's not a I don't know if they qualify it as medical transition or if they say transition with medical treatment.
Of course, yes, it's that. Yes, the policy says you cannot have attempted to transition, attempted to transition, intend to transition. So I think that would be kind of a categorical barrier there. Yes.
So in light of your responses to the questions here, how do you respond to the government's response that the only difference really between the Mathis policy and the Hexbeth policy is the difference between 18 months and 36 months? How long that period of stability has to exist, because everybody excluded them. Now, there may have been some undercover people, all right, so nobody knew. But once they acknowledged one way or the other,
Yes, Your Honor.
they were out.
Well, no, I think those two policies are about as opposite as two policies could be. The Carter policy is designed to permit qualified transgender individuals who've gone through gender transition to join the military and definitely to stay in the military once they're there, as long as they're meeting all standards. The Hexeth policy is the complete opposite. It's designed to keep all transgender people out of the military. The term stability is very misleading. The fact that the both policies use the term stability, I think, is a bit of a red herring, because
I understand you say there is no exception, but under the plain text of the policy, there is an exception.
Well,
and they acknowledge that the exception is much narrower than under the Mathis policy. But nobody could be in if they wanted to serve different from their birth sex.
Well, the so-called exception in the Hexeth policy, and the record on this is very clear, the district court made very detailed findings about this, backed up by unrebutted evidence, is that no transgender person could qualify for that exception. That exception, essentially, you have
The
to.
district court says that, but
Yeah.
the language in the policy talks about this exception. Now, whether it ever happens or not, that's another issue. But all I'm getting at is your answers to both Judge Wilkins and Judge Walker, it seems to me, line up quite nicely with the government's argument about, the limited differences in the policies.
Oh, my goodness. I mean, one is.
And I'm focusing on not the two people who want to join, who are plaintiffs, but everybody else who's in the military.
Well, under one policy, no transgender person under any circumstances can either join or remain in the military. Under the other policy, transgender people who are qualified and fit can both join and serve and remain in the military. I mean,
I think,
yeah.
Judge, correct me if I'm wrong, but I think Judge Rogers is asking about the difference between Mattis and Hegseth,
That's right.
Oh, the Mattis policy, yes.
not Carter and Hegseth.
Understood. So under
Sorry
the,
if I was.
I'm so sorry. I apologize.
I may have been on.
No, I'm sure it was me. I'm so sorry. Under Mattis and Hegseth. So under the Mattis policy, transgender people who were already serving in the military could remain in service. They will continue to get medical care. They continue to live and serve in a sex different than their birth sex. They would be subject to the just ordinary retention policy.
So Hexbeth says, our policy is different. It's narrower. Some people can continue to serve, but it's going to be a lot fewer.
Well, zero. Transgender people would be able to continue to serve.
They say, some military supervisor can issue a statement saying this person is absolutely essential.
I don't believe that, they have to meet the waiver requirements, which means that you have no history, you've never been diagnosed with gender dysphoria, you don't have it, you've never attempted to transition, and you have no intention of transitioning, i.e. you're not transgender. So, I think that.
You say i.e. you're not transgender, but as I understand it, all the plaintiffs say they are transgender.
And none of them would qualify for that waiver, which the government concedes because they're
the government
transitioning.
says it's still implementing the policy. The language is there.
No, Your Honor, the government has conceded very clearly that none of these plaintiffs qualify for that waiver. That's, I think, very clear. I believe I heard counsel reiterate that just earlier today, but it's also very, very clear from the record.
Can I just clarify? This is a facial challenge. You are not bringing an as-applied challenge, right?
Yes, Your Honor.
So, with respect to that, and I think following up on Judge Rogers's question, with respect to a session, put aside retention, respect to a session, your description of the difference between or the MADIS policy and the Hegseth policy with respect to the session is what?
They're very similar. They both are transgender enlistees.
Okay. So my question to you is, the district court made findings that there's animus and it's rushed and those sorts of things. But if the accession policy is materially the same under Hegseth than it was for MADIS, then what does the animus or the rush findings really, what work does that really do if all they're doing is essentially readopting a policy without any real material change with respect to a session than there was before?
I understand your question. I think we do have to look at the differences between MADIS and Hegseth that are relevant to the animus finding. And so the differences, are, as we've noted, the MADIS policy didn't result in the discharge of any transgender service member. It was,
I'm not talking about discharge. I'm talking about a session.
I understand, Your Honor.
Let me make it plain. We're not playing poker here. I'm gonna make it plain.
Yeah.
There were no animus findings with respect to the MADIS policy. That was maybe an argument that was there in the background, but that wasn't anything that was like really legally relevant. So I'm saying that if there's a policy that was adopted without animus, and then later on, it's readopted, and maybe, so let's assume for the sake of my hypothetical, there is animus.
Yeah.
But they're also saying that we're following the same objectives that the MADIS policy, the prior policy followed. We're adopting the policy for the same reason. So doctrinally, what work does this new animus policy do for you if the policy is readopted from a prior administration where there was no animus? You get what I'm getting at?
I do. I apologize for being slow to get it. I'm sorry. I do get it. So I do think it matters a lot that there was an intervening policy under Carter and the Austin policy that, again, was designed to provide equal treatment to transgender enlistees and did that, and that we have several years now of experience with that policy and zero evidence of any problems. And in fact, a lot of evidence put forward by the plaintiffs from senior military officials directly responsible for enforcing that policy, that it had only positive impacts, and that includes the accession policy. So that is now part of the record here. So for someone to come in, the whole rationale with Mattis was that we just don't know. There's some uncertainty here. I'm making predictions. I want to, err on the side of being as cautious as possible. Well, we do know now. We know now. We know. We have direct experience. We have unrebutted unanimous testimony from the very senior officials that were responsible for enforcing and overseeing both these accession and retention policies, that it was positive and it's working out great. These are qualified people. They're contributing to the safety and security of our country. So for someone to come in and just reverse that and go back to a policy that keeps everyone out based on a rationale that is completely now moot and outdated because was based on we don't know, well, now we do know. And in the context of much other evidence that this is driven by animus, then I think the animus does a lot of work there, a lot of work. It just shows, look, and that's one of the circumstantial factors that the Supreme Court has identified when you have a sudden reversal of policy, and there's no good explanation for why you're doing what you're doing. That is very probative of animus. And of course, we've got all the other factors here too, including
So what about the evidence that was in the record and Secretary Carter acknowledged this, but that when someone is kind of beginning treatment for gender dysphoria or going through transition process, it does affect deployability. And so isn't that a legitimate reason to treat accession differently than retention, because you're kind of at the front end perhaps of the transition process where deployability may be more of an issue with accession, but if somebody is already in, they've gone through the transition, treatment, etc., there's not as much concern about their deployability, availability, etc. So isn't that a reason why you would treat the two kind of groups of people differently, those seeking to join versus those who are already in and who have transitioned? And isn't there evidence in the record to support that concern about deployability? Because even Secretary Carter had those concerns, but the judgment was made was that notwithstanding that, we'll allow these people to join in the transition after they have joined.
Well, the record on this, the evidence on that point in this record is so clear. And that would also be the point of the 18-month stability requirement. Like, that's why there's that requirement. And again, that requirement is in no way unique to gender dysphoria. That's just applying the same generic criteria and framework applied to every other treatable medical condition. The military wants to make sure you've been treated and that you're stable in your treatment. So it's just even-handed, equal, applying the same rule. So that kind of addresses that. You do have to show you've been stable. But on the deployment issue, again, on this record, there was extensive unrebutted testimony from those senior military officials that there were zero issues with deployability and transgender people. And there's declarations from our plaintiffs. Multiple of our plaintiffs have submitted declarations saying, Erica Vandal, she did not even use a sick day. She transitioned in the military, did not miss a single day. Kate Coles, that's true of multiple of the plaintiffs. And I think people have this idea that, and I think Secretary Carter has some concern about this, but what we know in practice is that undergoing medical treatment for gender transition, as a general rule, does not involve any significant periods of non-deployability. For many of our plaintiffs, involve no period of non-deployability whatsoever. Dr. Brown has also unrebutted testimony on this in the record. And then, of course, there's the 2021 AMSARA summary that confirms that the rates of non-employability for transgender people are, to the extent you can make a meaningful comparison, favorable compared to others. So the record on that here is really, really clear. And again, the government had every opportunity to cross-examine any of these witnesses, to submit contrary evidence, and they chose not to do so.
With respect to heightened scrutiny of any sort, do you have anything you want to say with respect to why Spermetti doesn't control this case?
Well, Your Honor, I think Spermetti was very clear that it was cabined, its decision was cabined to the specific situation there, which is banning these particular medical treatments for young people. What we have here is a very different situation, where here we have the government adopting a policy that repeatedly on its face throughout the relevant documents targets transgender status as such. I mean, for example, nothing in that Tennessee law in Spermetti said that young people can't transition, that it doesn't say anything about how they live their lives, how they dress, how they refer to themselves. So what's the policy here is...
Policies are different, but the legal question, tell me why the legal question is different. The legal question was a classification that turns on age or medical use are subject only to rational basis review. That's what the court said. I'm quoting from the opinion.
Yep. Yeah. So here this goes to one of the central issues in the case, which is this policy based on transgender identity? Is it identity based? Is it intending to target people who wish to live in a sex different than their birth sex, transgender people, or is it just about a medical condition? And I think that the text of the policy and other considerations make it clear that it is targeting
But
transgender
you
identity.
seem to be wanting to kind of have it both ways, in the sense that you seem to be arguing that any person who has gender dysphoria is transgender, and any person who is transgender has gender dysphoria.
Well,
And if that's the case, then maybe the classification does only target transgender people. Well, but that's because it targets people with this medical condition of gender dysphoria, and your position, litigating position, is that all transgender people have gender dysphoria.
well, let me clarify that. I don't think all transgender people do have gender dysphoria. Again, if you've undergone treatment, you may not have gender dysphoria anymore.
But you're saying that, I asked you earlier, and you're saying that that doesn't have anything to do with your litigating position, because maybe some of your clients don't have it anymore, but you're saying that doesn't really make any difference with respect to this claim that you're litigating. So I don't see how you can argue that this is really not about a medical condition, it's about transgender status, when your position is that everybody with that status has the medical condition.
Well, I believe that our position is reflected in the expert testimony that we submitted that again was unrebutted, that gender dysphoria is highly treatable, and that when people undergo transition, it resolves the gender dysphoria. That is part of our record here, and the government did not rebut that. But also, I think it's also very important here, and Your Honor, that the policy on its face applies independently of gender dysphoria. It applies to anyone who's transitioned, attempted to transition, wishes to transition, refers to themselves with pronouns different than their birth sex, dresses different than their birth sex. I mean, it's really about transgender identity and status. It is not cabined. It includes gender dysphoria, but it goes far beyond that. I mean, it's part of a unified policy. It's a single document. it's very much focused on anyone who lives or wishes to live in a sex different than their birth sex is unfit for military service. And I think
But
that.
I think I've heard you say that all of those things that you just listed are things that would be considered symptoms or consistent with symptoms of gender dysphoria. So it appears your argument is, well, it's broader than gender dysphoria because it also includes people who exhibit symptoms consistent with gender dysphoria, even if they don't have or have never had that diagnosis.
Well, I'm only mentioning the symptoms consistent with gender dysphoria because that is one of the criteria in this policy. I mean, as the district court emphasized, I mean, this policy attempts to cover every
does the
possible.
policy, tell me one thing that the policy disqualifies someone for doing that would not be considered a symptom consistent with gender dysphoria.
Well, it's true that identifying as a sex different than your birth sex and wishing to live as a sex different than your birth sex or living as a sex different than your birth sex, that is a symptom of gender dysphoria, but it's also just it's just also part of what it means to be transgender. I mean, the fact that those overlap doesn't mean that transgender people are wholly defined by a clinical diagnosis. I mean, that diagnosis is there to help people transition, but it's broader than that.
I guess it's not maybe a perfect hypo, but let's suppose there were some medical condition that only people of a certain race could get.
Uh-huh.
But it's also a medical condition that could be seen as disqualifying a person from being in the military because of how it operates on the body or the mind or whatever, right?
Uh-huh.
So if the military says we are going to disqualify people from joining who have that medical condition, it just happens to be the case that all of the people who have that medical condition are people of a certain race.
Uh-huh.
Would we say, well, that's not really a classification based on a medical diagnosis? It's really a racial classification?
Well, I think we'd want to look at, is there a good reason, a legitimate reason to be concerned about that medical diagnosis? Is there a good reason to ban all people with that medical diagnosis? When you look at that question here, the answer is a resounding no. I mean, that's the issue here. The military is not,
All
they're
right.
not.
Well, I take that point, and I agree. You look at it, but all I'm saying is that doesn't mean necessarily that using that medical condition as the grounds for disqualification is equivalent to saying that they are only seeking to disqualify people of the race that has that. That's all I'm saying. Because what I have to do, and forgive me because I like rules and doctrines. I'm built as an engineer, and that's what I was in my former life, et cetera. But if the doctrine says that classifications that turn on medical use are in rational basis, and you are seeking to have me use a different rule, where it's a heightened review, not rational basis review, I need to understand how we get there, especially given, what the Supreme Court has told me. And just saying that, well, the people who have this medical diagnosis also happen to be this certain group of people. I don't see how that gets me to saying that this is a classification targeting that group of people.
Well, I guess what I would say is that these requirements that people have to live and serve in their birth sex are independent of the clinical diagnosis. I mean, they are, the policy, you could have a policy that simply had those requirements in it and not even include the gender dysphoria. And I don't think anyone would, just because those also happen to be symptoms of gender dysphoria, no one would be like, oh, that's a medical diagnosis. I mean, on its face, the plain language here, these are requirements that are targeted at a person changing their sex, living as a different sex. That's just about being transgender. It's a belt and suspenders approach here for sure, because the government's trying to sweep every possible transgender person in. And so they're also throwing in the gender dysphoria and symptoms consistent with gender dysphoria. But I think that does not alter the plain language of those requirements or how just unmistakably they're targeted at just being transgender. And, I think that's really, really just clear from the text, and also certainly clear from many statements that have been made, both in these policies themselves and contemporaneously by the president and by Secretary Hegseth, that they are very concerned with transgender people per se not being able to serve in the military.
All right. I don't want to preempt if others have questions.
I do have some questions, but I guess a while back, I thought I heard you just say that if someone if someone wants to transition if someone wants to, let me just, the recommended treatment for gender dysphoria includes assessment, counseling, and as appropriate gender transition. You would agree with that, I think.
Mhm.
Gender transition can include hormone therapy. It can include surgical interventions, and it can include social transition. And social transition would consist of, you might say, living one's life fully in accordance with one's gender identity. Is all that correct?
It's consistent with my understanding, yeah.
And have any of your clients transitioned socially without hormone therapy or surgical intervention?
Yes. Yes.
And that is the choice that many people who are transgender make. Is that also correct?
At least some do.
Okay, that clarifies something that helps me now. I have some more questions that are more about law than the facts of the case or definitions. Would you agree with this statement? Outside the elections and death penalty contexts, the Supreme Court rarely, if ever, reaches a decision on the merits that's different from its emergency docket decision.
I apologize, Your Honor, but I don't feel I have a basis to agree or disagree with that. I would have to look at the record on that.
Can you think of any times in the past 5 years where the Supreme Court has issued an order on the emergency docket that required it to make a finding about likelihood of success, made that finding at least by implication in favor of one party, and then ruled on the merits later for the opposing party?
This is just not something I have tracked closely enough to give you
Fair
a
enough. I appreciate it.
reasonable answer. Yeah.
A question about deference. Do you, this question may have been asked and answered, but I want to make sure I understood. Do you think the military has to submit contrary evidence under the military deference standard?
Not necessarily. I think they have to, Judge Wilkins is actually thinking of something from your concurring opinion in Shanahan. It's one thing to defer to the military's justifications. It's another thing to just ask the military to explain itself. So I do think that the military has an obligation to explain kind of the basis of its decisions and what they considered, what evidence was relevant to that. I don't think there's any requirement they have to have some certain type of study or evidence or something like that, but they have to have some basis, and they have to be able to explain it that they've adopted a reasonable, even-handed approach that's rooted in military needs.
What's the best precedent from the Supreme Court or this circuit for you where the case concerned a uniquely military matter like military preparedness?
I think Singh is very relevant here.
Which one?
Singh versus Berger. Rosker relevant as well.
Now, Singh was a First Amendment case, it was a RFRA case,
It
actually.
was a RFRA case,
So
yes.
I guess, and then Rosker, the military won.
Yeah, I understand that.
So I
Yeah.
guess, is there any case where the military has lost on a constitutional question when the case concerned a uniquely military matter like military preparedness?
I cannot, nothing is coming to mind besides the obvious, Chief Justice Roberts' recent clarification that Korematsu was wrongly decided. Of course, it went at the time, but yeah.
Slightly new topic. We're trying to figure out the meaning of due process, trying to figure out the meaning of the equal protection as found in the due process clause of the Fifth Amendment. Do we look to 1791? To the extent we care about its original meaning, do we look to 1791 when the Fifth Amendment was ratified, or 1868 when the 14th Amendment was ratified with an equal protection right that we now understand to be included in the Fifth Amendment?
I apologize. We are not prepared as I stand today to take a position on that. I do want to, there's something I just recalled. I do believe the Supreme Court has recently partially upheld a lower court ruling involving in favor of service members involving COVID vaccinations. And I apologize, I cannot call the case name to mind.
Okay. I'm not sure, but there was some emergency order work on that issue during COVID.
Yeah.
I don't have any more questions right now. I appreciate your patience, Judge Wilkins and Judge Roberts.
There was some back and forth on this administrative separation issue, and I wanted to give you an opportunity to respond to what your friend on the other side said about that. I guess what I'm trying to get to is I have to go back and listen to the oral argument, I guess. But it appears that there was a representation made at the oral argument on the stay having to do with administrative separation, and as Judge Pillard's opinion points out that gender dysphoria is treated differently than any other medical condition, and there's not the ability to have an individualized medical evaluation. Can you shed light on whether that characterization is true or not, and what is administrative separation, and is that different than the disability evaluation system, et cetera?
Yes, sir, I can. The statement in Judge Pillar's opinion that there's no other medical condition that automatically triggers administrative separation from the military rather than individualized medical evaluation followed by a determination of appropriate response is 100% correct. The that was the government conceded that at the hearing. And again, the record is closed and there's clear error standard here, but it is correct. It is correct. And for the vast.
If I wanted to find the answer to that, if I said, well, I'm not going to hold the government to this concession made at the podium.
Yep.
And I wanted to find the answer to that, where would I look to find the answer to that?
Well, the overwhelming majority of medical conditions that somebody who's already serving develops or has are processed through the disability evaluation system, which is an individualized assessment to determine whether that person can still do their job.
Your answer just defeated your goal. You said the overwhelming majority.
Well,
so it's not the only one.
Well, I'm getting
And
to
that's
that.
the government's.
No. Well, just give me 1 minute. Just give me 1 minute here.
Well,
There are.
I want to lead at this point in the argument with your strongest.
Okay, thank you. I appreciate that. Yes, so there's a handful of conditions that are very severe that are processed through administrative separation. However, and I'll just look at Joint Appendix 845 and 846. Even these handful of conditions there is an individualized assessment and that is 9.2 C 1 A and B, and you have an opportunity. The question is whether the disorder is so severe that the service member's ability to function effectively in the military is significantly impaired. And it includes documentation to establish.
So you heard the government's response, and why isn't that a full response? It says you get a notice of discharge, you have an opportunity to have a hearing before the 3-member board.
Well, that you do not get this individualized assessment for gender dysphoria. You do not receive
Well,
this.
council made this representation. You get this 3-member, and council can tell me if I misunderstood his answer, but that was part of it, that you get a notice of discharge, you can go to this 3-member board and make your case.
No, the only thing you get to do is the only question is, do you have gender dysphoria? If so, you're done. There is no assessment of, can you still function? Can you perform your job? And that is not true, even for these very severe disorders. I mean, gender dysphoria is so treatable. It's comparable
And we
to
know that you are correct because
just the policies. The policies themselves state that.
What about the government mentions schizophrenia? I'm not comparing that to gender dysphoria.
Yeah.
But I am asking, was the government correct when it said that someone is automatically, so they may get an individualized medical hearing, but no one with schizophrenia will be permitted after an individualized medical hearing to remain in the military?
No, sir. No, sir. They'll be subject to this individualized assessment.
What's your
And
support for the assertion that there's been one person who was not disqualified?
Well, it's not in the record, but from speaking with our experts and the senior military officials who administer these provisions, I mean, this is very serious. I mean, the overwhelming orientation of retention is to keep people in so long as they can continue to function and do their jobs or do any job where they're going to be useful to the military. And so that's true in the DES system. It's true for this very small number of very severe disorders that this is taken very seriously. And you can read from the text here that you can see there's all kinds of evidence that they're going to look at. And if people can still perform their job duties, they will be retained. And that is not the case for gender dysphoria under the policy, under the HECSET policy.
So I'm trying to make sure I understand precisely what you say the lay of the land is here. Are you saying yes or no that there are other medical conditions that trigger an administrative separation with no individualized medical evaluation?
No,
There's
No.
none of.
no.
Well, what was council telling us this morning about the Appropriations Act? And I can go look up all of these thousands of conditions that are listed.
If I,
Just talking about disability?
yes, ma'am, that's my understanding. Yeah, which is a whole different,
Right, so you
Thank you.
can't retire on disability if you have this condition. I totally agree.
Hmm.
All right, but that was his answer. All
yeah.
right, when I asked him about this very thing that the other two, see, I think it's amazing that we're getting all these different answers. And apparently it depends on who asked the question at what point in the oral argument. I mean, it's just,
I,
that can't be.
I understand.
It's either in black and white or it isn't.
I believe it is black and white in the regulations and the policy. And I just will also, and you know, this is why the district court gave the government opportunity to present evidence, supplement the record, come forward with
Well,
witnesses, and they
Looking
didn't.
at the Supreme Court, I think there are two chief justices who have made it pretty clear that in the military context, the military doesn't have to put on much, if anything. All right? And you got some 5-4 decisions. But that's the landscape you're facing. And the government has argued very strenuously to me. They said, yes, they talked about abuse of discretion, but it really isn't abuse of discretion. It's all just a matter of law. And there's no way you could prevail in the Supreme Court. And that was the implication of Judge Walker's question as well. I may be naive, but I think, you know, maybe if the court has a full oral argument on a matter and briefing, you know, it might qualify an emergency order or something. But that's neither here nor there. But I think there's some very strong Supreme Court decisions that present real difficulties for you in terms of your approach, in terms of what is the government's burden. And, you know, we're at rational basis. And the government has given us some reasons. And the Chief Justice has those language about, you know, if you can look around and figure out a reason, it's good enough.
All right. And I just quickly say then that I do think it's very important that the district court opinion in Schilling did not reach the question of animus, expressly declined to reach the question of animus, and relied primarily on finding that transgender discrimination gets heightened scrutiny. I mean, that's a new issue. The Supreme Court hasn't spoken to it. The Supreme Court has. I do think the doctrinal framework around animus is very clear, and the Supreme Court just keeps reaffirming it. This court, the court we have now, keeps reaffirming it, including in Scrimeti, where they did say that if this was a pretext, if there was evidence that this was a pretext for discrimination, that it was animus driven, that would be a different matter. And so I do think that makes a big difference. And the court, you know, has told us that when they don't issue an opinion, those shouldn't be read as like covertly overturning established law. And I think that legal framework on animus is at least clear. And they did just reaffirm that in Scrimeti.
But I guess what concerns me is some of the answers we're getting today, and it's in the briefing, I mean, it's nothing new, is that this kind of discrimination has been going on for years in the military. It's nothing new. All right. And if the military decides they need a uniform policy on uniforms, so be it. Court is not going to second guess that. 5-4.
I do think that's why it is important that the animus analysis and findings here are so important, because yeah, the military's had different policies, but they have been based on, you know, serious study of this issue and looking at relevant criteria and factors. And, you know, I think
The
that
government comes in and says, look, you know, we had a lot of study. Look at the Mathis era. We looked at all that. We've looked at the recent literature too. You know, and we've just reached a different conclusion than you have. All right? And that's the point about military preparedness.
I do think it matters that when you lay out every single factor that the Supreme Court has ever identified as relevant to a finding of animus, they're all present here and that the district court made such detailed, I mean, more than 80 findings of fact, very detailed analysis, and did give the government every opportunity to explain or rebut, and, you know, they chose not to. And I think on this record here, her factual findings supporting the conclusion that this is an animus-driven policy are very solid. So I do think that matters under the Supreme Court's current case law, and I think this Supreme Court will take that very seriously. I mean, they just told us in Scrimeti that would make a difference to them. And, you know, and even in Trump versus Hawaii, it was a external statement months earlier by the president, but it prompted them to undertake an examination of whether there were legitimate reasons for that policy. And here, you know, the demeaning derogatory statements are in the policy itself. The contemporary statements are instantaneous. None of the other criteria or factors that the court said sort of rehabilitated that policy in Trump versus Hawaii are present here. And I think these things really do matter. And I do think the court has given a very clear legal framework on the animus question. And then the facts here, the factual findings are so detailed and so strong and by the government's own prerogative, largely unrebutted. And I don't think they can come back now and just disagree with those facts on a clear error standard. You know, I think it does really matter. I mean, these are folks who are serving our country very honorably at very high levels, and the government admits they have done nothing wrong, that they are exemplary, their service is exemplary, and thousands of them, if you all, you know, decline to let this PI go into effect, are about to suffer really severe irreparable harm. It's going to be harmful to them, harmful to our country.
All right, I think Rick Walker has a couple of questions before we wrap up.
I recall the Supreme Court majority saying in its Obergefell decision when describing the issue of gay marriage, when describing the traditional view, that this view has long been held and continues to be held in good faith by reasonable and sincere people here and throughout the world. I think in this litigation, some people think some incendiary things have been said by. I think you think that they've been said, and I think the government might think that incendiary things have been said. So I want to give you an opportunity to answer a couple questions with that Obergefell quote in mind. Some people believe that service members with some mental health conditions, not necessarily gender dysphoria, but with some mental health conditions, make military readiness less ready. That view has long been held in good faith by reasonable and sincere people, correct?
Which is why there's an individualized assessment.
Fair enough. Some people think that sex is fixed at birth. That view has long been held and continues to be held in good faith by reasonable and sincere people here and throughout the world. Do you agree?
You know, I think that what's important for this court, for this case, is the policy in front of us. And I think that policy was undertaken with a very deliberate intent to exclude and demean transgender people.
What about outside the context of this particular Hegseth policy? Do you think reasonable and sincere people acting in good faith can disagree about whether sex is fixed at birth?
You know, that's such a broad question. I don't have an opinion on that.
Last one. Same question, but with regard to whether service members should live in their birth sex, many people disagree about whether they should or shouldn't. Do you think that both views are held in good faith by reasonable and sincere people?
Again, I think what counts here is whether the government can impose a policy based on disfavoring transgender people in order to exclude them from military service while conceding that they're meeting all standards and are fit to serve.
All right, if there are no further questions, I'll give you, if you want to make 30-second closing argument or not, but I'll give you that opportunity.
Yeah, I just appreciate your patience and thank you very much.
All right, thank you. So, Mr. Cambley, I know we greatly exceeded your time, but you had asked for 3 minutes for rebuttal, so I'll give it to you.
Yes, Your Honor. So just a few things that I wanted to point out. Judge Walker, you stated that you were going to ask me questions on the symptoms consistent with. So I would direct the court's attention to footnote 2 of JA 1289, which states the phrase exhibit symptoms consistent with gender dysphoria refers to the diagnostic criteria. And in the DSM, and the language applies only to individuals who exhibit such symptoms as would be sufficient to constitute a diagnosis.
So I wanted to ask you a question about that because this whole symptom issue has come up. And I thought maybe in your reply, where you write, you comparing these two policies, Mathis and the Biden.
Yes, Your Honor.
Where you say, but these differences, like any difference between the 2025 policy and the Carter and Austin policies, simply reflect a more cautious approach to the, quote, risk associated with allowing the accession and retention of individuals with a history or diagnosis of gender dysphoria, close quote, quoting JA 69. And when I read that, I thought, are you saying that the court should read the HEFSA's policy statement to be limited to those with a history or an actual diagnosis of gender dysphoria, as opposed to the broader language about people who have symptoms consistent with gender dysphoria?
Yes, Your Honor. And that scenario is just designed to cover people who might be suffering from gender dysphoria but never received a formal diagnosis.
So my question is, in your reply brief, that's your response. And I read it and I thought, well, is the government taking the position that the court should read that language about consistent with to be only for the risk associated with people who have a history or a diagnosis, which to me is a lot narrower than saying, and also, by the way, people consistent with?
Yes, Your Honor. It's basically people who experience enough clinical distress to be diagnosed with it, but
Is that a yes to my question?
So, Your Honor, we don't believe that there is a significant amount of daylight between those two positions. Since
I asked the question.
Yes, Your Honor, we do, but the policy
So
says.
should the court, I'll repeat it, read the HEFSA policy in line with what I just quoted from your reply brief at 25?
So, Your Honor, it should be read in line with what the policy says on its face, which
And
is.
not what the government has argued to this court in its reply brief on page 25.
So, Your Honor, to the extent that it wasn't intended to be read as anything different than what the policy
Well,
states.
you're making a very strong statement. And I thought they're pulling back because they realize, symptoms consistent with, I have a hiccup, I have a sniffle, I have a cough, it's just too broad. Whereas what you're saying is anyone with a history or diagnosis, surely that is what the administration is focused on.
And that is, Your Honor, because that's what footnote 2 clarifies.
Right.
Symptoms consistent would be enough to have a diagnosis. So
That's my point.
Yes, Your Honor.
So we should read that symptoms consistent to be the same as and equal to either a diagnosis or a history.
correct, Your Honor.
Not read the policy more broadly. That's all I want to be clear.
Yeah, that's correct. Yeah,
Thank
because
you.
that's why the footnote 2 is there, because there was
We
some,
were, we were told something about a self-reporting requirement if
Yeah.
you feel a different gender than your birth sex, but you've never done anything externally to indicate that.
so Your Honor, that's not what the policy says. So I've been in the military for about 13 years now, and every year I have to take a physical health assessment where I fill out an online questionnaire saying, hundreds of conditions, whether I have them or not. And
But we're just told the form is being changed. So you will have to answer about,
gender dysphoria, yes.
but symptoms consistent with.
And
So if you have a headache or temperature, you're going to have to say yes.
that person would not be intended to say yes, Your Honor. It would be someone who suffers the clinical distress and has the other symptoms that would be enough to form a diagnosis. But the self-reporting, that applies to hundreds of medical conditions. So that's not something, that form is not something new. It's just that gender dysphoria is one of the conditions that's on the form.
And it's asking to self-report distress or impairment.
No, it's asking to report gender dysphoria or a history of or symptoms consistent with. And with the symptoms consistent with as is defined as the DSM-5 criteria,
Which are?
which are listed on JA 1292.
And what does it say?
It says it's a marked incongruence between one's experienced / expressed gender and natal gender of at least 6 months in duration as manifested by at least 2 of these following 6 conditions. And then says the condition is associated with clinically significant distress or impairment in social, occupational, or other important areas of functioning.
All I'm getting at is that's so broad. You could be distressed for all kinds of reasons that have nothing to do with gender dysphoria.
They have 6 criteria that you have to meet at least 2 of. So it is defined there.
And the distress has to be distress or impairment has to be caused by your
Yes.
gender identity.
Yes. Yeah, and it has to be a clinically significant level of distress.
And so, go ahead.
I'm confused. I want you to answer this yes or no. If a person has never had a diagnosis for gender dysphoria, but they say that they have symptoms that could be construed as consistent with symptoms for gender dysphoria, does the Hegseth policy disqualify them from, let's start with accession?
So with accession, it would only be if it's enough to form a diagnosis. And I don't know what that scenario.
Say that in the policy. That's why I thought you might jump at this phrase that you wrote in the reply brief, because it clears up all that.
So yes.
That's not what's in the policy, and you won't say that this is it.
It is. It's in footnote 2 of JA 1289 that says symptoms consistent with. That language only applies to individuals who exhibit such symptoms as would be sufficient to constitute a diagnosis. So that part is in the record.
So you're self-diagnosing in addition to self-reporting.
So if you believe that you suffer from gender dysphoria because you meet the DSM criteria, there's nothing that prohibits you from self-reporting, but then the military would still.
I'm getting at, if you're in the military and you want to continue to serve, why would you ever self-report?
So
Right? You have a sniffle, you have a headache, you're all distressed about some emotional event.
So, Your Honor, it's the same thing with other conditions such as anxiety or depression. They ask those questions.
Right, but at least you get an individualized assessment.
So, Your Honor, if you do mark that box, there would be a further medical evaluation to determine whether you actually do suffer from gender dysphoria, is my understanding. But that goes
I
towards.
agree, that is not in the policy, however.
So it says if during a PHA, a member is identified as having a current diagnosis or history of or exhibiting symptoms consistent with gender dysphoria, the facility or location conducting the PHA will be responsible for conducting or coordinating any follow-up medical evaluation if necessary and for notifying the service.
That's for people who have, as you write in your brief, a history or diagnosis.
Yes, Your Honor.
You don't want to talk about this other language in the policy that talks about symptoms consistent with. That's the self-diagnosing in the self-reporting. And why,
So
given the policy and the way it reads, would you ever self-report?
it's the same reason.
Self-defeating.
So it's, Your Honor, it's the same reason you would self-report for any other mental health condition that would be disqualifying. So for instance, if you believe you suffer from depression, you might mark that box yes, but there will still be a follow-on medical treatment to determine if you actually have a level of depression that would warrant a diagnosis.
You've told me that you don't get this individualized assessment. And certainly you don't get this three-member panel
So,
disability. So I don't know what you'd get other than you get a letter saying you're discharged. Thank you very much for your service.
so Your Honor, just to clarify, the disavowed, what I was referring to was a very particular process that was listed in the policy about a disability evaluation system. That's what I was referring to earlier. The administrative discharge board is an option that the member has, and that's what Judge Wilkins was referring to when he talked about where you have to appear in the hearing in the uniform of your biological sex. That's the three-member panel I was referring to.
All right. But under the policy, then, as you read it in its broadest plain terms, if a member of the military self-reports symptoms consistent with, he or she is out, right?
So, Your Honor, that doesn't necessarily mean they're out because it still has to be enough to form a clinical diagnosis. And
Where is that stated?
So, Your Honor, that it states in as I mentioned in footnote 2 of JA 1289 and then 1290 that talks about follow-on medical evaluation.
No, but that's not in the policy itself. That's all I'm getting at. I'm
It's-
trying to understand this policy, and you're telling me read it in light of all of this military background, et cetera. But when the plaintiffs want to talk about military background and environmental issues, you say, no, we just have to look at the four corners of the policy. So I'm looking at the four corners of the policy, and I'm perfectly willing to do that.
This is the four corners of the policy. It's
Yes.
the March 21st, 2025 memorandum, subject prioritizing military excellence and readiness, military department identification, and that's in implementation of this
That's
policy.
February 5th,
The March 21st.
the March 21st. Okay.
Yeah, so that is in the policy.
So before we adjourn, I just want to make sure that I understand your position. The statement in Judge Pillard's dissenting opinion, citing to the oral argument that says there is no other medical condition that automatically triggers administrative separation from the military rather than individualized medical evaluation followed by determination of an appropriate response. Is it your contention that that statement is false?
No, Your Honor, that is accurate. And I was just talking specifically about the disability evaluation system, which is an option for some, but not gender dysphoria. There are a number of processes. And while it is also possible for other people to be, or other conditions to be treated in a administrative separation discharge, that is correct in terms of the automatic triggering.
You heard the questions that I asked a few minutes ago. I just asked them to you as well. Some people think sex is fixed at birth. Some people disagree. Some people think service members should live in their birth sex. Some people disagree. Do you think both views can be held in good faith by reasonable and sincere people?
Yes, Your Honor.
All right, thank you. The matter is submitted.
Thanks. It's